Normanton, Pontefract and Castleford, Yvette Cooper.
Thank you, Mr. Speaker. I beg to move that the European Union Withdrawal No. 5 bill now be read a second time. And I want to start by welcoming some of the words of the Prime Minister from yesterday. She said as part of her announcement that this is a difficult time for everyone and that passions are running high on all sides of the argument, and that debate and division is putting members of Parliament and everyone else under pressure and also doing damage to our politics. And I think we all recognise the pressures she is talking about, and also, I think, recognise the efforts that members on all sides of the House and with all kinds of different views on Brexit are making to do the right thing in the national interest, to do the right thing from whatever their different views are on Brexit, and to do the right thing for their constituents as well. And I hope that the tone of the debate that we had, the very respectful and thoughtful tone of the debate that we had on the programme motion, will be continued in the debate this afternoon as well. We have put forward this bill as a cross-party bill in order to avert no deal on April the 12th, and done so for fear of the damage that no deal would do to all of our constituencies. We understand that the Cabinet Secretary and National Security Advisor to the Government, Sir Mark Sedwill, told the Cabinet yesterday that no deal would make our country less safe. And the Cabinet have a responsibility to listen to that advice, and I'm extremely glad that they did. We understand... We understand too that the Cabinet was warned that food prices would go up by 10% in the event of no deal. And again, I am glad that they listened to that advice, because that would have a huge impact on overstretched families across the country. I will give way to the honourable member at the back first.
Thank you. I thank and I endorse the tone with which she has brought this. Can I just ask her, though, Mr. Speaker, given she has been one of those who has most vociferously argued for long periods of scrutiny over our decision to leave the European Union, why it is, though, or why she thinks it is acceptable to take off the table a way out of the European Union that very many people who voted to leave the European Union believe to be the way in which we should leave, and why, given her previous demands for long scrutiny, this is all being done with only a few hours of debate in this place.
So, he is right that this is a tight timetable for this bill, because this is a tight timetable for the House, facing the deadline of the 12th of April, facing the European Council meeting that will take place. And I will be honest, I could never have imagined when we started these debates that we would be in a situation where 9 days from Brexit Day nobody knows what's going to happen. And that is causing huge concern and anxiety, I think, for businesses, for families, for people across the country. And I do also think, and I will come on to in a minute, some of the damage that no deal would do to my constituency and to many other constituencies. I think we have a responsibility to ensure that we can avert it. I will give way a couple of times. I am conscious of wanting to just make some progress as well on the bill itself. I'll give way to my honourable friend.
Well, I'm very grateful to her for giving way, and I share her frustration that it wasn't time for a bit more of scrutiny. But wouldn't that come better from someone who hadn't just voted against the amendment, would have allowed us to discuss it on Monday?
Well, I think that it would have been better to have further discussions on Monday, but we are where we are, and I think the important thing today is to make sure that we can debate no deal. I'm going to give way just 3 more times, and then I'm going to actually make some rapid progress. I'll give way to the honourable member.
I greatly appreciate giving way. Thank you very much. I have the greatest respect for her endeavours today and what she's trying to achieve. But is it not the case that one of the things we have to do in this House, and she mentioned it at the beginning of her speech, is that we are all used in here to battling for our ideology and our belief and what we want. And this is one of the rare occasions when it is appropriate for us to think not what we believe in and what we fight for, but what is right for the country. And that some of us, both Remainers and Alternatives, we need to compromise and meet somewhere in the middle.
So I say I completely agree with the honourable member, because I, in fact, first proposed a cross-party commission straight after the referendum to oversee the negotiations, and then I proposed it again after the general election, because I was fearful that we would end up in a kind of gridlock, and I thought it would be best done in a way that builds consensus. So I do agree with her the importance of that.
I thank my right honourable friend for giving way. We wouldn't surely be in this position had the Prime Minister not run down the clock, and we wouldn't be in this position if the Prime Minister had perhaps reached out across the House sooner.
I think we would all... Look, the truth is we've been trying to squeeze into a few days a process of consensus building that really should have taken 2 years, that should have started a long time ago. And that's why I think it's so important to make sure that just at the point at which we are trying to come together and build some consensus, we don't just tumble off the edge of a cliff. We don't just end up doing unfair damage to our constituents. I could wait.
The Right Honourable Lady is being very generous, and I appreciate the way she's introduced this debate. But may I just gently remind her that predictions have been proved so wrong in the past about the consequences of voting to leave or no deal. We heard dire economic predictions in 2016. By Christmas 2016, 500,000 extra unemployed. The economic reality has been very different since. They were wrong then, and I suggest to the lady they're wrong now.
I think the honourable member is talking about the assessments that were made about the impact on confidence immediately after the referendum itself. That, I think, is a very different assessment from the impact of things like WTO tariffs. I mean, that is something, a really practical thing, where you can see what the impact is going to be of those numbers, or some of the other issues in terms of the border capacity, if you need to do customs checks. Those are very practical things, which have not yet come into place, and I hope will not, because I think frictionless trade is so important to our constituencies. I'll give way one final time.
I thank my right honourable friend for giving way, and I'm pleased to co-sponsor her bill today, because actually it has been done on a cross-party basis. It's been done by all people who want to prevent a no deal from happening, because they've been listening to the CBI, the TUC, all of the voices in our constituencies. And whatever our views on where Brexit goes, we all believe we must avoid that catastrophic no deal, and whatever the progress of this bill tonight, this House is resolved to avoid that.
My honourable friend is completely right. And let me just quickly tell you some of the points that have been made to me about why this is so important. No deal would mean we would immediately lose access to the European arrest warrant and access to crucial criminal databases. A Castleford police officer told me that no deal would mean it is going to be incredibly difficult for me to do my job properly. Obviously, with more serious offenders, such as sex offenders, who will travel, this is going to cause serious concern. No deal will also mean the kind of border delays that have led the NHS to have to do stockpiling. A friend told me in Pontefract that he is waiting for radiotherapy for his cancer treatment and does not know if that treatment will be delayed because short-life isotopes cannot be stockpiled. Major manufacturers and producers in our area, like Burberry, Haribo, Teva, have told me how hard they would be hit by WTO tariffs, by customs checks and by border delays. And I think we should be standing up for British manufacturing abroad and not holding them back. And local small businesses particularly have told me how much they fear if they are dependent on imports. They simply don't have the margins and could end up going bust if their stock is delayed. And local trade unions who have warned about the impact on jobs. And perhaps I fear most of all the impact of no deal on some of the most overstretched families in my constituency, where we've had to set up hungry holiday clubs for kids who are on free school meals who may go hungry in the Easter holidays, and in Airedale we've had support and free lunches for families, and those families are going to really struggle if there is a 10% hike in food prices, and it is simply not fair on them. I'm going to make some progress first before I give way, because I have given way very many times. And therefore, I think we have a responsibility. I know that there are members across this House and there are people across the country who say they would like to see no deal happen and they would like to see it happen as soon as possible. I would just simply say it will hit other people's lives and it is not fair. And for the sake of the Castleford police officer, for the sake of the Airedale families, for the sake of the Pontefract and Normanton manufacturers and the small businesses and the cancer patients across the country, that is why I think we do have a responsibility to make sure we have a system in place to prevent no deal on April the 12th, just 9 days away. Let me just say something about the Prime Minister's process first, and then I will give way and another round of giving away. The Prime Minister has announced her intention to pursue an extension, but the reason for continuing with this bill is because there is no clear process for how those decisions will be taken about the length of extension and the context. And what this bill does, therefore, is it does a few things. First of all, it provides some clarity about how those decisions about the length of the extension will be taken, gives a role for this House in that process. And I think it also ensures that we don't just slip back into facing that no-deal cliff edge almost by accident because of the nature of the difficult conversations and the complexity of what we're all facing. And perhaps crucially, it will demonstrate to the EU parliamentary support for what the Prime Minister is asking for. And to be fair to the EU, given the turbulence we've had in this House at every stage along this process, that actually is quite a reasonable thing for them to ask whether the Prime Minister has the support of the House in the things that she is asking for. I will give way very briefly.
And I congratulate her on her bill and the progress that she's made thus far. She speaks clearly based on evidence, and I'm delighted, as I expected from her, she's clearly listened to business. And would she agree with me that the Secretary of State for Business, we can only assume, has also listened to business, and of course he's looked at the government's own impact assessment of no deal, and he claims it would be ruinous for our country. Does she think he's right?
Well, I think that we should take seriously that assessment, but not just from the government ministers, but also from the CBI and the TUC, who have come together in, I think, a very powerful way to say very strongly the damage that it would cause for us to be simply left with no deal. And I think, therefore, that many of us have been trying to make this process work, trying to come together, trying to deal, whether it be through proposals that we've made through select committees for different Brexit policy options, whether it be work that we have done calling for consensus or putting forward indicative votes and options. I think there has been a lot of work done, but where we, I hope, will share our views is that we should avoid that no-deal Brexit. I am conscious of really needing to finish one and then final two, and then I really have to not, because it's not fair for the people.
My honourable lady for giving way, and she knows that I support the broad thrust of this bill, but I'm concerned that it doesn't say when the Prime Minister has to ask for an extension, and it also doesn't seem to provide for the situation where Parliament has asked her to go for an extension longer than the 22nd of May, but she doesn't want to do so. It doesn't seem to have enough teeth to me. Could she address those points?
I think the purpose of it is it does say, it does spell out that on the day after the day on which the Act receives royal assent, the Prime Minister must move the motion in the House of Commons, and it also does provide for the government to be mandated by what it is the House has voted for. This is a two-clause bill. This is a two-clause bill. I will in a second. I will in a second. This is a two-clause bill, and that's all it is. It's very simple. It requires the Prime Minister to put the motion to Parliament proposing an extension to Article 50. It asks the Prime Minister to define in the motion the length of the extension. Parliament can debate the motion, can seek to amend it in the normal way, and the conclusion is binding on the government. The Prime Minister has to take that to the EU. If the EU Council agrees and that is resolved, if the EU Council proposes a different date, the bill proposes for the Prime Minister to come back to the House with a new motion. So the bill simply provides for a simple, practical and transparent process to underpin the Prime Minister's plan. It makes sure the extension has the support of the House of Commons, but also that we keep that parliamentary safeguard in place. So whatever is agreed by any further talks, any further indicative process, or by the Prime Minister's approach, by any of these different options, the Prime Minister herself has said nothing can be implemented by April the 12th. And therefore, in only 9 days' time, the Prime Minister has recognised she cannot implement anything by then, and that is why the extension is needed. And I think, Mr. Speaker, this is, I think, a hugely important bill. I am conscious of allowing other members. The honourable member has been standing up a lot.
For giving way, she's being very generous. Would she agree with me? She's clearly had a conversation with senior police officers. The impact on the European arrest warrant apparently is an average 6 weeks to process cases now would transfer to an average of 6 months. Would she like to speculate on the impact of that sort of delay in terms of processing very serious cases?
Right, and I've also heard, for example, the ECRIS, the Criminal Records Database, then at the moment they can access criminal records in a matter of days, but actually this could take weeks as a result. We've had that evidence on the Select Committee. I give way.
To the Right Honourable Lady. Just simply a question. Would the Right Honourable Lady be able to tell the House how long the extension will be? Because that is also a matter of principle. It's not just a matter of committee. How long does she expect the words in square brackets to be? Is it going to be 3 months, 9 months, 2 years? What will it be? And secondly, doesn't the Right Honourable Lady agree that it is quite extraordinary that if it was to be an extended period, it would cost the British taxpayer billions and billions of pounds?
Can I very gently just point out that there are 3 front bench speeches to be heard and a number of other honourable and right honourable members who wish to speak in the debate. Therefore, there is a premium upon brevity. Yvette Cooper.
Thank you, Mr. Speaker. The bill deliberately does not specify because it should be for the Prime Minister to put a proposal forward. The Prime Minister has to go into the EU Council and has to do the negotiating. She also has to lead the process around indicative votes. So I think it is right that she puts that forward and then the House will decide. I am just very conscious of the front benches. I am very conscious of front benches needing to speak. Can I just make my final point? I think there is it's really important for people to come together, both as part of this process and in how we go forward, because the challenges that we face from the threat of no deal are very significant. In my, I think it's 3 years on from the referendum. The biggest problem for all of us is that so little has been done to heal the national Brexit divide or to bring people together. And this is major constitutional change. And if there isn't that effort made to bring people together, then to be honest, whatever we conclude, either today, tomorrow, next week, it won't last because there won't have been that work to build the consensus. I think at the moment we all know there is no agreement and no consensus on the best way forward. We hope we can reach it, but at the moment there is no agreement. Let's at least sustain our agreement about ruling out the worst way forward. I beg to move the bill.
Martin Vickers now.
Well, the question is that the bill be now read a second time. I've just had a message shunted to me from a government whip that the Secretary of State is content to wait for a period, and the honourable gentleman, the member for Cleethorpes, is the beneficiary. Mr. Martin Vickers.
Right. Thank you very much, Mr. Speaker. I was only just beginning to write my speech, but I'll muddle along. Needless to say, Mr. Speaker, as a almost lifelong Brexit supporter, I'm speaking against the proposal. I recognise that across the House there are members who quite genuinely did not want to leave the EU. They believe that the best interests of our country lies as a member of that union, and that's a perfectly honourable position. But what I find objectionable is those who are quite deliberately seeking to frustrate the will of the British people, so clearly demonstrated in June 2016. And in my particular constituency, there was a 70% vote to leave. I'm pleased about that because, of course, I was one of them, and I have campaigned long and hard to achieve this. In fact, I know I don't look old enough, but I did actually vote in the 1975 referendum, and of course I voted to leave on that occasion. And that was I'll happily give way to my neighbour.
I thank you for giving way. Is it not the case, though, that many of our constituents who, as he says, voted by a margin of 70% to leave the European Union, now think that what's happening, and this is the problem with bills like this, is that there is a stitch-up taking place to try to deny the result of the referendum? And it's all perfectly fine, people talking about people coming together, but when legislation is put forward to deny a way of leaving the EU by people who are on the other side of the campaign, our constituents only feel more that this place is out of touch with them and that this is all one massive stitch-up.
Absolutely. My honourable friend and neighbour is absolutely right in his analysis of the situation. And moving on, if those who, for example, are arguing for a second referendum, the so-called people's vote, as if it wasn't people who voted on the last occasion, I'll give way one more time to my honourable friend.
Your neighbour, but it's very. Thank you very much for actually letting me intervene. I would actually very much agree with him that we've had a people's vote, and that happened in 2016. I actually voted and campaigned Remain, but I believe we must respect that vote and we must get on and leave the European Union. And lots of people on the other side are just thwarting it, even though in their manifesto they actually were campaigning to leave the European Union as well.
Thank you. I thank my honourable friend for that, and although he's not my neighbour, he is of course welcome to visit Cleethorpes at any time, and he will be made most welcome. I was moving on to talk about a second referendum and the uncertainty and division that will actually continue. Are those members who think it will resolve the issue seriously suggesting that if we were to have a rerun and a lower turnout, that perhaps a scenario could unfold where 16.4 million people voted to remain, and because it was a lower turnout, they actually won? Now, do you think that would satisfy the 17.4 million who in 2016 voted to leave? Of course not. It would continue. It would continue the division and uncertainty, and we would be battling on for another 20, 30 years about our future in Europe. I think what you've got to remember is that to a great extent, it was an emotional vote by people. We had Project Fear that told them they were going to be worse off, that taxes were going to rise within days, hours even, of a decision. In actual fact, they said, well, that's fine, let's look at that. But we want to leave, not because of some potential downturn in our economy, but because it's a cultural issue. Our history, our structure of government in Parliament, our judicial processes are different, and we were having to make more and more changes to our established processes. Well, I'll give way first to the honourable lady.
Thank you, Mr. Speaker. I'm very grateful for my honourable friend giving way. The vote itself was on our membership of the EU. It was not about our future relationship. All those emotional matters that my honourable friend raises may well have been sold to them during the campaign, but the vote itself was about our membership and therefore cannot be prayed in aid in terms of how it shapes our future relationship.
I strongly disagree with my honourable friend. They voted to leave the structure of the economic union, and they wanted to slam the door closed. They wanted a clean break with it. They weren't thinking about our future relationship. They said we've had enough with the existing relationship. I give way to my honourable friend.
My honourable friend is making an excellent speech. I mean, what he also, I'm sure, will agree with is that, in addition to the emotion, actually they were proved right, because despite all the predictions of doom and gloom in 2016, the economic reality since is that we've had a strong period of economic growth, and those investment decisions have been made in the full knowledge that we could be leaving on no-deal WTO terms.
That's right. I entirely agree with my honourable friend. So we move on. They made that decision to leave, and they expected us to be leaving, and they certainly expected us to be leaving a lot quicker than 3 years. Now, it is suggested that if we go back and rerun the referendum and so on, it will all people will change their mind because of the economic arguments and so on. The reality, I think, is very different, and I think we should recognise that, as I recall the Attorney General saying in one of his outings in the House on this issue, this is now come down to a political decision, and the political decision should follow the result of the referendum. And I think there will be an enormous backlash against not just the party in power, but the political classes. If as the people see, they see the door in front of us marked exit, and we are seen not to step through it. And I would urge the House to vote against this and to continue the battle. And if we end up with no deal, then so be it.
Thank you. I would like to encourage colleagues to make speeches not exceeding 3 minutes. In fact, there will be a 3-minute limit on backbench speeches. The front benches are going to be encouraged to be extremely brief. Lots of people want to speak, very little time. Caroline Lucas.
Thank you very much, Mr. Speaker. I want to lend my support to this important bill because I think it's a vital safety net to ensure that we don't crash out with no deal next week and that we have enough time to find a constructive way forward. Many others have already spoken very passionately about the impact that no deal would have on business. Also, they've spoken about the impact on some of the most vulnerable, and of course, no deal would affect the poorest communities hardest. I wanted to say a few words about two areas. One, about how I think that if we don't pass this bill, we do put at risk the Good Friday Agreement. We do risk greater insecurity and tension in Northern Ireland, and I think that is absolutely a criminal thing to do. I am inordinately shocked, even knowing what I know, that 14 members of the Cabinet appear to be positively enthusiastic about leaving with no deal. I can't think of anything more irresponsible. But I want to say a few words about environmental protection as well, because no deal is a disaster for our environment. It would lead to a huge governance gap where not only do we not have the environmental policies which have been key to protecting our environment in this country, which have come from Brussels, but we would also lack the enforcement agencies that are absolutely crucial to making them go forward. I'm not going to, just because I've been told I've only got 3 minutes. There are huge further concerns about no deal, crossing everything from security to medicines to fissile materials to pharmaceuticals. I want to point something else out about trade agreements to you, because we often hear on the other side that somehow when we're outside of the EU, when we've crashed out, it's going to make it easier for us to make these trade deals. I would put it to them that if they're looking at us as a potentially trustworthy partner in a trade deal, are they really going to want to conduct trade deals with a partner that has crashed out of the EU and which has presumably not even paid its divorce bill either? I think this would make us look incredibly untrustworthy. And finally, let's not have all of this stuff about how there's some kind of stitch-up to prevent us leaving the EU. Those people on the other side can't possibly say what was in the minds of those people who voted leave nearly 3 years ago. But what we do know was that, in fact, it was 37% of the electorate, and it was nearly 3 years ago, and that no ballot was not on the ballot paper at that referendum. How on earth can we be taking such far-reaching actions that will cause such damage to our constituents and to our environment on the basis of an electorate that was little over a third nearly 3 years ago? At the very least, Mr. Speaker, this absolutely has to go back to the people. We can't possibly be pretending to be acting in their name unless we have the courtesy to go back to them and check this is what they meant. And frankly, from everything that I know, from the people that I've been speaking to up and down this country, they did not mean the amount of devastation and destruction that will be caused to this country by crashing out of the EU with no deal, which is why this bill is so important.
Thank you. John Barron.
Thank you, Mr. Speaker. I do find it very strange, this sort of condescending view that people didn't know what they voted for first time round, so we're going to give them a second vote, and if we don't like that result, we'll give them a third and a fourth. It is complete nonsense. No, because we've been told to be brief, and I'm going to be brief, and we've been guided by Mr. Speaker on this. Can I just ask the House just to reflect for a moment and use moderation when it comes to this issue about so-called crashing out or falling off a cliff by leaving on no-deal WTO terms. I would gently remind the House that in 2016 there were lots of dire predictions about what would happen if we voted to leave. We had predictions from the trade bodies, the business organisations, from the government, the Treasury front bench. We had predictions of 500,000 extra unemployed by Christmas 2016. The CBI came out with a figure of 950,000 extra unemployed within a couple of years. They all proved wrong. So much so that the Bank of England actually had to apologise. Now, what has happened since? We've had record low unemployment, record inward investment, and record manufacturing output. And I suggest to the House that the reason we've had that is because economic reality, trade, and comparative advantage trumps predictions. And when we talk about comparative advantage, it's factors such as how low are our corporation tax rates compared to other countries? How much more flexible are our labour markets? What about our financial expertise, unrivalled certainly within Europe? Our R&D, our top universities. It is these issues, these factors, which in aggregate are more important than WTO tariffs and leaving on no deal. And the proof of the pudding is in the economic reality. Our unemployment rate, and we would all agree a low unemployment rate is terribly important. High unemployment is one of the social evils in our society. But our unemployment rate is nearly half that of the EU average. And this is the issue in point. And we trade with many countries outside the EU very profitably on WTO no-deal terms. So I would suggest to the House that if we want to respect the referendum result, the triggering of Article 50 and our own election manifestos, then we should be leaving the EU on the 12th of April on no-deal WTO terms if we can't agree a deal before then.
Mr Brake, no? Tom Brake.
I really just wanted to say a few words about a conversation I had earlier today with business representatives from, amongst other places, Northern Ireland, for instance, who were very worried about the
European Union Withdrawal Number 5 bill.
Absolutely.
Yes. Tom Brake.
Specifically on the issue of no deal and the impact, which clearly is what this bill is about, ruling out the possibility of no deal, and their concerns around the impact of VAT being applied. But they went much beyond that in terms of the impact of no deal on Northern Ireland and the impact on security, for instance, and the issue that I referred to earlier in terms of the impact on things like the European arrest warrant. And for no deal, the impact on things like labelling and the uncertainties around whether, for a company that manufactures here but also has shops in other parts of Europe, whether they need to change the labelling. So clearly the impact of no deal goes far beyond just some of the issues that have been raised here today. And I hope that what this bill will provide is some clarity on the issue of the extension. Clearly, I'm quite open in believing that extension needs to be a lengthy extension, the sort of extension that businesses were talking to me about earlier today. And that is one way of ruling out no deal. There was just one final point that I wanted to mention, which was just on the question of, I think, the point that was made by the spokesperson for the Greens, and that is on the issue of the legitimacy of the vote of 3 years ago, and specifically the way that trade union legislation, as I understand it, requires ballots to be rerun after 6 months' time to ensure that they are valid and that the views that were expressed in a ballot 6 months earlier are valid 6 months on. And clearly that is something which I think could equally apply to a ballot, if I can put it that way, that took place 3 years ago. So I do hope that we will allow this bill to proceed through the second reading. I know there are a number of amendments at committee stage, one of which indeed applies to a people's vote, and I hope that we will get to debate that shortly as well.
Antoinette Sandbach.
Thank you, Mr. Speaker. And I rise to support this bill for this reason. We are seeing the revisionism of history by ERG members who claim that 17.4 million people voted for no deal. That is not what was on the ballot paper. What was on the ballot paper was our membership of the EU. Many of us in this House have triggered Article 50 on the basis that what we were doing was saying to the EU we will not remain a full member, but we want to have a new relationship with you, one that might look like Norway, one that might look like Switzerland. We may be in EFTA, but that, in fact, that was campaigned for on the campaign trail by Vote Leave. And Vote Leave's electoral registration made it absolutely clear that the decision of the future relationship would be up to Parliament, that what voters were voting for was to leave the political institutions of the EU out of the ECJ, out of the ever closer union, but not ruling out the single market or the customs union. So why has this House ruled out no deal? It's because we have faced the reality of what leaving with no deal would look like. We are due to do that in just over a week with no process in place. And if we are to change that, we need to change the law. And Parliament has voted by 400 votes to 160 against no deal. This bill is not undemocratic. It implements that decision. We have not ruled out leaving the EU. We are still leaving other options open for our future relationship. And I am somebody who has supported the Prime Minister's deal 3 times. I have voted on behalf of my constituents to implement their decision in the referendum. The problem is that there are a hard core of ideological WTOers that want to hold this House to ransom and want to hold the country to ransom. And I have distressed businesses saying we must resolve this. I have employers who live in my constituency. I'm sorry, he spoke so many... no, I'm so sorry. I have really distressed employers in my constituency who are responsible for thousands of employees that would like a resolution. And what this does is give Parliament, this bill gives Parliament a proper say in the event that we cannot get to a resolution in the timeframes currently set out. So far from being undemocratic, this is about putting a process in place that allows us to implement a decision, that allows us to have time to look at the best way we can implement our future relationship with Europe. And that is why I shall be voting for it.
Used to 2 minutes. Joanna Jerry.
Mr. Speaker, it's a real pleasure to follow the honourable member for Edinburgh, who has been one of the voices of sanity on the government benches throughout this debacle. Others, I'm afraid, are living in cloud cuckoo land if they still believe that no deal is not going to be a disaster for the economy of these islands. In my constituency of Edinburgh South West, we have the second biggest financial sector in the United Kingdom. We have 2 major universities, Heriot-Watt and Napier, and I have many businesses, small and large, that are very concerned about the impact of a no-deal Brexit. And of course, Mr. Speaker, my constituents didn't vote for Brexit at all. 72% of them voted to remain in the European Union. So I support the general principle of this bill. I have to say that I think it has some serious shortcomings, but it's all we have at the moment. It's the only insurance policy we have at the moment against a no-deal Brexit. I would have preferred to have seen something with far more teeth in it, such as the proposal I put forward on Monday. And I do have a number of questions about this bill which have yet to be answered. I'm worried that the bill does not say when the Prime Minister has to ask for an extension of time. The European Council is next Wednesday. It doesn't say specifically when she has to ask, whether she has to ask before then or on that day, nor does it say what happens if the European Council give us an extension with conditions attached, such as a longer extension, and nor does it say what happens if the Prime Minister won't contemplate extending beyond the 22nd of May, but Parliament has forced her to ask for a longer extension. It seems to imply she could sit on her hands. So I think it's right for a bit of amendment, this bill, and certainly the SNP will be trying to lay some amendments if we get to that stage. Thank you.
Thank you. I'm going to call each of the 2 remaining members, but each will have no more than 2 minutes, and the honourable gentleman must be reseated by 6:50. Okay. Sir William Cash.
Very briefly indeed, Mr. Speaker. I just want to make one point which I have referred to briefly before, and it is this. This entire process, as my European Scrutiny Committee report made clear, back in March last year, is being driven by the guidelines and the humiliating supplication of the European Union by the government and the Prime Minister. That is true and it is clear. Furthermore, what happened with the reversal of the position on Chequers when the Withdrawal Act itself, which had been overtaken by events, was then, on a pre-planned basis, then turned into a new arrangement which became the withdrawal agreement. The final point I want to make is this, that with regard to supplicating the EU, there is a profound humiliation for the British people in our being required to do what they say. And what this bill will do will be to ensure that they dictate the terms, and the basis on which that will be done, as Sir Paul Lever and I and others have made clear over the years, it will be decided by Germany in the Council of Ministers and in the European Council. He says, and I say, this is a German Europe, it is run by Germany, and that is the bottom line, and that will happen in relation to this decision as well.
Well, that is one of the shortest speeches the honourable gentleman has ever delivered in the chamber. 2 minutes, Mr Bob Seeley.
Much indeed, Mr Speaker. I will not be supporting this bill, the European Union Withdrawal No. 5 bill, because it is delay without end. Business above all wants certainty. I don't believe all the scare stories. The Treasury, sadly, has been proved wrong in most of its assessments of Brexit. And this bill is simply going to be the water torture of endless delay. I make my decision-making on 2 points. Firstly, we have to honour the referendum result. That means voting for Brexit. I do so because the country voted for it. I do so because my island, the Isle of Wight, voted for it. I do so because the best way of improving the reputation of politics is for politicians to do what we said we would do. And the problem is that we are not doing that. And this chaos is self-induced by people who do not want Brexit. Second, we have to live in the real world, and that means accepting that this Parliament has a Remain majority. It has been obvious for months that we were not going to get a no deal through, and whilst I respect the Right Honourable Member for Stone and many other Brexiteer colleagues, I cannot think of a more perfect example of snatching defeat from the jaws of an acceptable victory. There has never been a chance to get no deal through, as we are finding out. We are not theologians. We need to cut a deal, not philosophise on the nature of Brexit perfection. I do not think, thank you, I do not think, I'm so flattered to be criticised by both sides, I know I'm right. I do not think this deal is too bad. I think the alternatives on the Strictly Come Brexit dance-off next week will be another well-meaning shambles, and what is truly obvious at this stage, mind-numbingly, stupefyingly obvious, that if we want a deal and we want to leave with a deal, we should vote for one. Thank you.
Mr Peter Grant.
Thank you very much, Mr Speaker. On the 18th of July 2018, the SNP became the first party in this Parliament to call for an extension of Article 50 deadline. The need for that extension, and a real extension, is more urgent now than it was then. So although we have a number of concerns about the wording of the bill, we will compromise on those concerns just now, support the bill and hopefully improve it at the next stage. Mr Speaker, the Government are still trying to blackmail this House by insisting that it's a choice between the Prime Minister's rotten deal and no deal at all. That claim is simply not true. Revocation is still an option. We will be hoping to amend the bill to make that perfectly clear. I commend my honourable learned friend for the part she played in confirming that. In a court case in which Her Majesty's Government spent £150,000 of our money sending lawyers to the European Court just to tell the court they didn't have a view on the matter under discussion, which seemed a good use of money. And ironically, possibly the best way in the long term to get the Brexit that people actually voted for would be to stop this insane process and start all over again before it's too late. I was disappointed that Labour didn't fully support that motion when my honourable friend put it forward previously. I think it was a mistake. I hope they'll accept it was a mistake and support it if they get the chance again. We do have a concern that the bill at the moment leaves too much in the hands of a Prime Minister who can't be trusted to get anything right, so we'll be seeking to get that amended as well. We also need to have a clear reason for the extension, and that will dictate how long the extension has to be. Our preference would be to have an extension to allow a people's vote, not a rerun of a referendum from 2016, but a different vote at a different time on a different question. If the government were confident that their withdrawal agreement had the support of the people, they wouldn't be running away so quickly from the chance to give the people their say on that. Mr Speaker, this morning, or earlier this afternoon, my honourable friend from Roskilde Lochaber held up a copy of Scotland's Place in Europe, and it was held out by the Conservatives in this House. But, Mr Speaker, they can laugh at Scotland's Place in Europe. Scotland's place is in Europe, and Scotland is about to retain its proper place as a full sovereign member of the family of European nations.
Thank you. Mr Paul Blomfield.
Thank you, Mr Speaker, and our thanks too to the Right Honourable Member for Normanton, Pontefract and Castleford and the Right Honourable Member for West Dorset for their work on this bill and the way that they've introduced both the business motion and the bill itself to the House. We support this bill because it's necessary to fulfil the wishes of the House, which has voted down the Prime Minister's deal on 3 occasions and has voted against leaving without a deal on 3 occasions. Very briefly.
Can you think of another example when the TUC and the CBI have been as emphatic as they have been about the dangers of a no-deal Brexit?
I can't, and that underlines the importance of this bill, which provides for the further extension of Article 50, which is now inevitable, and it offers a legislative framework through which the House can have an effective role in the process of determining that extension. Now, clearly, the bill sits in the new context of the Prime Minister's statement late last night, saying that she was seeking talks with my right honourable friend, the Leader of the Opposition, and those talks which have begun. We welcome what the Right Honourable Member for Grantham described as a late conversion to compromise, although we regret the damage that has been done both to the economy and to the credibility of this House by her not doing so sooner. It's an approach that she should have adopted long ago, almost 3 years ago after the referendum, when the country decided by a painfully narrow margin to leave the EU, but not to rupture our relations with our closest neighbours and most important trading partners. She could have done it after the election, when she went to the country saying Parliament was obstructing her and seeking a mandate for a hard Brexit, and she lost her majority and failed to get the mandate. And she could have done it on any of the 3 occasions when her deal was defeated by the House. But she chose not to. We have, Mr Speaker, consistently called on her to reach out to the sensible majority in this House and to unite the country, recognising that the people of this country include both the 52% and the 48%. But better late than never. We also welcome the way that the Prime Minister distanced herself last night from those kamikaze colleagues who, as she said, would like to leave with no deal next week. This House has expressed its clear view on leaving without a deal, and this bill provides the legislative lock to ensure that the will of our sovereign Parliament is not frustrated. It also provides the flexibility to ensure that we can accommodate whatever comes from the discussions between our parties and across the House over the next few days. We have set out clearly the framework on which we will be seeking a compromise that the Prime Minister talked about last night: a permanent and comprehensive customs union, close alignment with a single market, dynamic alignment on rights and protections, clear commitments on participation in EU agencies and funding programmes, and unambiguous agreements on future security arrangements. And we've been clear in our support for a confirmatory public vote on any deal that comes about at this very late stage. We look forward to the further discussions on these issues, and we're pleased to give our full backing to this bill.
Exiting the European Union, Stephen Barclay.
Thank you, Mr Speaker. We will oppose this bill. It is passed in haste, and the fact we have a time limit of 2 minutes for a number of the speeches this evening is an indication of the fact that the bill is being passed in haste. It is constitutionally irregular. And it also fails, frankly, to understand the decision-making process by which any discussion of an extension or agreement on an extension at the EU Council will be reached, and I will come on to that in the limited time that I have. It's not just myself, Mr. Speaker, that has concerns with this bill on behalf of the government, but objections to the bill have been raised by the chairs of the European Scrutiny Committee, my honourable friend the member for Stone, by the chair of the Procedure Committee, my honourable friend the member for Broxbourne, and indeed by the Public Administration and Constitutional Committee chair, the member for Harwich and North Essex. All have raised concern with the bill. In particular, the fact that this is being rushed through in such short order, and indeed the precedent this sets for not just this government, but also for successive governments. It also calls into question, Mr. Speaker, the royal prerogative, as it has been a long-standing practice that heads of government are able to enter international agreements without preconditions set by the House, which constrain their ability to negotiate in the national interest. Let me give you an example of how that constraint could actually have an adverse effect, particularly given that the House has voted against no deal, how it could increase the risk of an accidental no deal. For example, on Wednesday the 10th of April, the European Union could propose at the Council an extension of an alternative length. Yet under the bill, the Prime Minister must then return to this House on Thursday the 11th of April to put that proposal to the House. But by the 11th of April, the European Council will have concluded, the leaders will have returned to their member states. And so we would then need to confirm the UK's agreement to the decision of the European Council and get the European Council's approval to that by 11 p.m. on April the 12th. And I think what's at the heart of this is the fact that last Friday, in voting against the withdrawal agreement, which was the only legal right this House had to an extension to the 22nd of May, which was at the heart, Mr. Speaker, as I understand it, of your decision to grant that vote, because, as the Attorney-General set out, that was an additional right bestowed on the House as a result of that previous EU Council. We have no automatic right to a legal extension. That right was foregone by the decision of the House last Friday, and yet this bill puts the House in the position of having to agree after the European Council has concluded, and those leaders have returned to their member states. Of course I'll give way to the honourable friend.
He is very generous in giving way. Who ran down the clock?
Well, I think it's not usually my practice to quote the front page of The Guardian, but I suspect it is the newspaper of choice of the honourable gentleman, and we all remember the headline. Indeed, it was quoted by many EU leaders, which said no, 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 because this House has failed to agree on the various options. The Prime Minister has sought to compromise. Indeed, part of the challenge she has had with her deal is because people on both wings of this debate feel it is too much of a compromise. So the Prime Minister has sought to compromise in the national interest, reflecting the fact, as members have said, 48% of the public didn't vote to leave. And that is why the Prime Minister has sought compromise. It is why she sought to reach out to the Leader of the Opposition, but he refused to meet her for several weeks. Indeed, he even refused to meet when Chuka Umunna, the member for Streatham, happened to be in the room. This was apparently beyond the pale. I'm pleased that today I was able to join the Prime Minister at a meeting with the Leader of Opposition. But when it comes, as the honourable gentleman says, to running down the clock, it is the fact that the House has consistently voted for what it is against, not what it is for. And indeed, the decision the House took on Friday not to approve the withdrawal agreement was the very essence of running down the clock. Because what it did, I've only got a minute left, what it did was it waived the right that we had to an extension to the 22nd of May, and therefore only gave an extension to the 12th. That is the very essence of running down the clock, and the honourable gentleman voted for that reduction in time. A very odd thing, Mr Speaker, to criticise a reduction in time whilst having voted for the very reduction to which he complains. But given that we are passing this bill in haste, given that we don't have adequate time to debate this in the manner to which I would like, given there is only a minute left on the clock, there are problems with the speed of this passage, there are problems with the constitutional principle of it, there is problems with the way operationally it will interact with any decision reached by the Council that differs from the earlier decision taken by this House. So I hope the constitutional experts in the other place will address some of the flaws that are contained in this bill. But it is because of those defects that this government will oppose the bill tonight, and I urge other honourable and right honourable members of this House to oppose this defective bill.
Under the order of the House of today, I am now required to put the question. The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. No! Division! Clear the lobby. The question is that the bill be now read a second time. As many as have that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Jeff Smith and Nick Smith. Tellers for the noes, Wendy Morton and Craig Whittaker. Order.
The ayes to the right, 315. The noes to the left, 310.
Thank you. The ayes to the right, 315. The noes to the left, 310. So the ayes have it, the ayes have it. Unlock. Order. Under the order of the House of today, we shall now move to Committee of the Whole House. Order. Lindsay. I think. Yes, I take the point of order before we go into committee. The Chairman of Ways and Means is present and correct. Point of order, Sir William Cash.
Just been to the vote office, and most unfortunately, for some reason we can't understand, a copy of the bill that we should be getting is actually malfunctioned in some way or another, so they can't actually be obtained from the vote office as I speak, as I understand it.
Well, that a bill is itself capable of malfunction. My imagination, which is quite vivid, is being stretched. But it may well be there has been some malfunction that has caused the absence of the bill which the honourable gentleman wishes to see and of which he would want a copy. That is unfortunate, and I hope the matter can be speedily remedied. I've just been advised, I'm grateful to both members, the Harwich and North Essex, and for Rayleigh and Wickford. It was the amendment paper that was not forthcoming, but I gather that honour is served, the amendment paper is here, the Chairman of Ways and Means is in his place, he's made his selection, the House is going to hear it, and order.
The clerk will now read the title.
European Union Withdrawal Number 5 Bill.
I'll wait till you get back, Joe. Don't worry. I must inform the committee that I have selected the amendments and new clauses as grouped with clauses stamped out on the selection paper available in the vote office. Just before I start, my provisional grouping and selection of amendments is now available. There will be one group with votes at the end by 10 p.m. at the latest on the lead amendment on which the question has been proposed from the Chair. Other amendments to Clause 1 selected for separate decision. Clause 1 stamp out. Any amendments to Clause 2 selected for separate decision. Clause 2 stamp out. Any new clauses selected for separate decision. I am not going to enter into a debate for my reasons for selecting or not selecting amendments and new clauses to this very narrow single topic bill. We start with Amendment 13, with which it will be convenient to discuss amendments to Clauses 1, Clause 1 stamp part, amendments to Clause 2 stamp part, and new clauses as on the order paper. So I now begin with Amendment 13. Sir Oliver Letwin to move.
Thank you. I move formally.
So the question is the amendment made. The question is the amendment been made.
Anybody else wish to speak?
Nobody wishes to speak?
Yes. Where is it?
Sorry?
Mr. Amuna stood up.
Chukamuna.
16. 16?
The list is available. I've not been printed. Aye. Oh, good.
Thank you, Mr. Deputy Speaker. Unfortunately, with the noise of people entering and leaving the chamber, I didn't catch which which amendments had been selected, and I wondered if you could clarify for the House which amendments had been selected.
13 plus 20 plus 21, Government 22 plus 1, plus Clause 1 stamp part, 14 plus 6, plus 2 stamp part, plus new Clause 4, new Clause 5, new Clause 7, plus Government new Clause 13. I hope that helps the House. And somebody just won the bingo call. Now then. Point of order, Tom Bray.
For the benefit of the House, Mr Deputy Speaker, is the grouping available for members or not?
I thought it was available and should be available. Well, if not, it's still being done. I think the problem we've got is that the tight time scale, we're trying to play catch-up a little bit. That's why I'm trying to help and move from here. Simon Malthouse.
Deputy Speaker, thank you for repeating these amendments that have been selected. Could I ask, perhaps, if you could repeat them again and a little bit more slowly, because we couldn't get through the paper fast enough?
I'm hoping the list arrived.
We've got some lists here. I assume they're out.
Point of order, Sir Alderman.
I'm very grateful, Mr Deputy Speaker. Would it not make sense to suspend the sitting for 10 minutes in order to make sure that all members present can have both a copy of the amendments and the selection list that you have spoken about?
Suspend for 10 days, that would do it.
I'm just trying to see if we get an indication of where we are up to with the printing and duplication, why they've not been handed out. Nothing is yet forthcoming.
Not yet, there's a few minutes. So perhaps we'll suspend.
So what? Rather than suspend, I will help repeat and see if we can make progress with the numbers again.
Well, we haven't got the amendment papers in the vote.
OK, duties in connection with Article 50 extension. 13. 20. We've already had that joke. Already had that, Mr. Linden. Repeat jokes don't count. 21. 22 plus 1. Clause 1 stamp out plus 14. Plus 6 plus Clause 2 stamp out plus new Clause 4 plus new Clause 5 plus new Clause 7 plus Government new Clause 13. For the benefit of the House, I will run through it once more. 13, 20, 21, 22 plus 1, Clause 1 stamp out plus 14, plus 6, plus Clause 2 stamp out, plus new Clause 4, new Clause 5, new Clause 7, plus Government new Clause 13. Does that help, members? Point of
Just thank you very much, Mr Deputy Speaker, for clarifying the amendments you've selected. Can you just be absolutely clear how they have been grouped? Are we debating them all as one large group or in separate groups?
One single group, as I said, we will take the votes all at the end. And that should help the House. Now then, is there any other issues, or should we begin to make Mary Craig?
Mr Deputy Speaker, there are no more lists of the amendments available from the Vote Office. Can you ask that there should be some more urgently made available, obviously for the purposes of members to be able to have some? They're all out.
Yeah. Just to help the Right Honourable, just to say, yes, we're trying to get the list as quickly as possible, and we are playing a bit of catch-up. No, we know where we need to start, and we could begin to make a start on one while they're being distributed, rather than because we are up against a bit of time, and I want to see who wish to speak, and I look round the chamber of who's going to stand. Yvette Cooper. Point of order. Sir Nicholas.
Lindsay, in the spirit of the new regime of bringing the whole House together about these difficult matters, and while you are waiting to get these amendments circulated, I thought it would be helpful if I was to let the House know that the Grand National will be run by a horse called Tiger Roll.
Mr Hanson.
In order to be helpful, Mr Deputy Speaker, and whilst awaiting the formal written list, could you advise as to what stage you will take third reading before 10 o'clock? Because it would be interesting to know how long we have for discussion of the amendments which will be forthcoming very shortly.
If the committee takes up all the time, there will be no third reading. So that's up to the House. So that's why I want to try and get progress and try and get opening some of the speeches. So I look round to see who wishes to speak. Yvette Cooper.
Thank you.
Sorry, Sir William.
I'm most grateful. You've just called, I think you called, amendment number 13, and in the selection it says Yvette Cooper. As it happens, I have here the table of amendments, and number 13 is in my name.
Yes, here. When's third reading? We'll all make it up.
Well, just to help the House, on my sheet of paper, which we're working to, it's in the name of Yvette Cooper. The Right Honourable Yvette Cooper. Yvette Cooper.
Thank you, Mr Deputy Speaker. If I may, I will just briefly move the drafting amendments in my name and the member for Dorset West, and then I will respond to the other amendments at a later stage in the debate once other honourable members have had an opportunity to move their amendments. These are just two minor drafting amendments. The first is that simply corrects in Clause 1, page 1, line 6. Instead of referring to Section 2, it should refer to Section 1. And then the second amendment is Amendment 14. And rather than referring to the 2018 Act, that should properly refer to the European Union Withdrawal Act 2018. So these are simply clarifying. I will give way to the member.
Because I looked through her bill last night, at the drafting of Section 1, subsection 2. I hadn't seen her proposed amendment. But is this not the difficulty of trying to make law on the hoof, where we've had 55 minutes only for second reading, and there's a most obvious drafting error in her original draft bill, and a simple mistake of getting the wrong section, and reading through it, simply not understanding at all which bill she was referring to? Doesn't this show the very danger with such an important constitutional change of trying to make law on the hoof?
I have to say to him, I just think, sadly, this is the consequence of us being 9 days away and that is not a situation that any of us wanted to be in, to have the clock run down this far with no agreement in place, and given that the Prime Minister didn't put any withdrawal agreement to Parliament until January, and then it's been put back several times and we haven't had a clear plan. So I think in those circumstances that that is the situation we're in.
Baker. Mr Deputy Speaker, it may help the House, having just inquired in the Vote Office, the correct amendment paper which we should be looking at is the one with 15 printed pages of amendments, 1515. There has been some confusion which would explain the point of order from my honourable friend for Stone, but the correct amendment paper has 15 printed pages.
It's correct. Yvette.
Thank you, Mr Deputy Speaker. We just give way.
I thank my honourable friend for giving way, and I entirely agree with the point she was making before the point of order. And would she not agree with me that actually we've all been in committees where government legislation is brought forward, and yet they have to bring forward at every stage, every day, often tens or hundreds of drafting amendments, let alone before it goes to the other place. So would she agree with me that actually a couple of minor things here which have been spotted and are being addressed is actually nothing compared to what the government normally does?
I would agree with that. I would also say that, in fact, this bill, its intent and provisions are actually extremely simple, and that we're making decisions on. We understand that the government is going to ask us to make decisions because of the timescale on some very big things over the next couple of days before the European Council. I give way.
I'm afraid that although they got the numbering of the actual amendments wrong, I'm afraid the drafting amendment to which she seems to be referring now, under her Amendment 13, is itself rubbish. And the reason for that is very simply this. Her amendment states that leave out Section 2 and insert Section 1. But unfortunately, that doesn't help anybody for a very simple reason. Because the actual provision refers to Section 2, which is now to be referred to under the amendment, if passed, to Section 1 of the European Withdrawal Act 2019. What is the European Union Withdrawal Act 2019? I thought it was passed in 2018.
Oh, good question.
Yes, it was. I will give way to the Honourable.
Very grateful the Honourable Lady for giving way. I would have thought that my Honourable friend would recognise that that is a reference to the Act that this will become, the 2019 European Withdrawal Act, should it be passed into law.
The honourable member is exactly right, and that is why there are two references to two different bills for clarification. There is one reference to a 2019 bill that this will become in Clause 1, Subclause 2. There is another separate one as part of the drafting amendment in Clause 2, Subclause 1, which refers to the previous bill in the previous year. I beg to move those amendments.
Thank you, Mr Deputy Speaker. In a way, I rise to speak to all of the amendments which are supposed to relate to the duties to be exercised under the bill. And one duty in particular is omitted both from the bill and all the selected amendments. And I know that in making these points, I'm supported in so doing by the Right Honourable members and honourable members for Twickenham, Brighton Pavilion, Ross, Skye and Lochaber, and Dwiffor, Merionid, and I'm sure I've pronounced that incorrectly, and others. And we argue that really, with this bill, you should attach to the intention of the bill the purpose for which it is sought. The European Council has been absolutely clear that the UK will not necessarily be granted an extension for a general purpose, but that we will need to specify what it is we wish to have an extension for. And on various different occasions, senior officials of the various EU institutions have been clear that they would grant an extension for the purposes of holding a people's vote. And yet no such purpose is referred to in any of the amendments that have been selected or the bill itself. It is all well and good to argue against no deal, which we have been told lies behind this bill. But to be sure of getting the extension to stop no deal, particularly if you are a member of this House who will not entertain revocation of Article 50, it's clear that to stop no deal, there needs to be a duty that you not only request an extension, but it is for the purposes of something that will lead to us being granted the extension we require, which is a people's vote. I'll give way to my honourable friend.
I'm very grateful. Isn't it even more serious, given that the Prime Minister and the Leader of the Opposition are cooking up some plan today, which also doesn't refer to the people's vote? Absolutely.
I completely agree with my honourable friend. And in a way, why is this all so important and how have we been brought to this point? It is because our democracy is deadlocked. We are faced with a perfect storm created by the clash of mandates. The clash of mandates between I'll give way very shortly to the Father of the House, but we are trying to work our way through dealing with a clash of mandates between views expressed by a majority of people who participated in a referendum in 2016 and views expressed in a general election which has led to a hung parliament and the chaos in this House of Commons. I'll give way to the Father of the House.
The Honourable Gentleman was quite correct in saying we would have to produce a reason for wanting an extension, but doesn't he think the reason that would command wide support here would be so we could clarify the political declaration and develop the ideas of some sort of customs arrangement, some sort of regulatory alignment, mapping out our future relationship? And doesn't he agree that most of the European nations would welcome that development, and probably a very long extension to the end of 2021 would be quite readily available?
I do not disagree at all with the Father of the House. I think that a long extension would be preferable. I do not think there is anything for us to be afraid of in terms of European elections. After all, it's called democracy, and at least it means that more of our constituents can get involved in this process. But one of the things that has been said when we look at the different elements of this bill and the duties that we are seeking to impose on the government is that to find a way forward through all of this does require compromise. And I would say, and as I've said, I believe there should be a duty in this bill for the government to seek an extension in order to provide for a people's vote. Now, why do those of us who argue for a people's vote want a people's vote? We want to give the British people the ability to take a different course. And in so doing, there is compromise there.
The easy thing, if you wanted to stop Brexit from actually happening, would to be simply to ignore the 2016 result.
Obviously, it is quite tight, and I'm going to allow some flexibility to discussion. And what I would say is we don't want to concentrate that's something that's not even down on the order paper tonight. So, by all means, I will allow some freedom, but let's not concentrate on opening up too far. Chuka Amuna.
I take the point of the Deputy Speaker, but all of this goes to the duties in the bill, and there is a big glaring omission from this bill and from the amendments that are stated within it.
I'm grateful to my honourable friend. His points are particularly relevant to new clause 4 and new clause 5, tabled in the name of the honourable member for Stone, which seek, I believe, artificially to restrict the nature of amendments that could be placed in relation to any motion on an extension. And I think it's very relevant to new clause 4 and 5 for us on this side of the House to say no. There should be greater latitude for the sort of issues to come into that.
I think, in fairness, it's my judgment that we'll take. Thank you for your advice. But actually, it's the opposite way, not the way that you're trying to open it up. What I've said is I will allow flexibility, but I'm not going to dominate on the debate that's not part of it tonight. Chuka Amun.
Thank you very much, Mr Deputy Speaker. I'll give way to the honourable gentleman.
I just wonder whether the honourable gentleman realises something about his clause, which is that, of course, I'd be very happy to see this inserted, because I think this immediately would mean that this would need a money resolution, so I give him good encouragement.
We're not talking to a new clause.
We're not talking, unfortunately, I wish it were the case that our amendment had been selected, I say to the right honourable gentleman. But my point is that the purpose for which the extension is sought is not stated as being necessary in the duties of this bill. I should just say to Mr Deputy Speaker, I apologise if he doesn't believe that I'm speaking strictly to the amendments. Part of the challenge, I suppose, has been raised is the way in which we're conducting this debate and the fact that we're trying to do justice to the committee stage of this bill, having only discovered your selection, Mr Deputy Speaker, very shortly before. So perhaps I just...
Gentlemen, in fairness, I also only got it minutes before, so it's much harder for both of us to try and deal with it. Chuka.
Absolutely, I'm just making an observation. But just I'll very quickly finish the point that I'm making. Ultimately, there is a need for compromise here, and we are at that stage in this process where I think that is what the public expects. To provide for, within the duties of this bill, a provision where the government seeks an extension for the purposes of a people's vote is in itself, I would argue, compromise. In part because there are ways that you can do a people's vote which would take account of all the different views that have been expressed in this House, which would involve compromise. For example, we do not like the Prime Minister's withdrawal agreement or framework for the future relationship, but would be prepared not to stand in the way of it if it were put to a confirmatory vote. I'll just finish by saying this, Mr Deputy Speaker, and perhaps explain why I'm so keen to crowbar in these points into this debate. If we don't address these points and through a backroom deal we ignore the fact that a people's vote is not provided for in the duties of this bill, what are we saying to the 1 million people who marched on the streets of this city? What are we saying to the 2 million young people who now have a say on this whole issue but didn't 3 years ago? What are we saying to the 6 million people who signed a parliamentary petition in frustration that a people's vote may not happen, arguing for a revocation? And what are we saying to the majority of people in this country who certainly didn't vote for this mess? And that is why it is very important that if we're going to seek an extension, we're clear that we want to do so primarily to give those people voice and so that they get a final say on whether we go ahead with this disaster or whether actually we seek to change our country in a different fashion.
Thank you, Mr Hoyland. Can I begin by thanking the House of Commons clerks for the immense amount of work they put in to ensure that we have these amendments in order, ready to be debated, in what is clearly a rather unprecedented type of bill to bring before this Parliament. And in common with my honourable friend, the member for Newbury, I have been somewhat supportive of my right honourable friend, the member for West Dorset, in terms of his attempts to create space on the agenda of this House to discuss indicative votes. Indeed, I've tabled amendments of my own during those votes, and so to date have actually voted for the business of the House motion, abstained on the business of the House motion to enable those debates to take place. But today I didn't do so because, like my honourable friend, the member for Newbury, I do believe that this is a very different type of reason for taking control of the House. And I wanted to rise to speak to my two amendments, Amendment 20 and 21. Amendment 20 seeks in subsection 3 of clause 1 a maximum date of the 30th of June 2019 for that elected by the government, and Amendment 21 deletes altogether subsection 6 and 7, which make provision for how this House would deal with a situation where the European Union had rejected an approach by the government to seek an extension and instead made a counter-offer. And my reason, Mr Hoyle, for making both of these amendments is that, as a number of honourable members have pointed out, this legislation is indeed rushed. We can all have views and comment on the reason that it is rushed. Indeed, we are rather at the 11th hour in this issue of leaving the European Union. But it does mean that this is a very unusual bill, in that it is seeking to bind the government, the hands of the government, on a decision that would be normally a matter of prerogative power and a matter for the executive to take to negotiations in international fora. And both of these amendments recognise the fact that this bill has now passed second reading and is therefore in play, but nevertheless seek to place a restriction on the scope and power of that bill. So Amendment 20 says that while any date can be placed in Clause 1, Subsection 2, as provided for in Subsection 2, that there should be a maximum date of the 30th of June 2019, and it should not be possible for a date to be elected either by the government or by amendment in this House that goes beyond the 30th of June 2019. And I think that is a very important principle given the rushed nature of this legislation. It would enable both this House and the government and the Prime Minister to seek an extension, a short extension, as the Prime Minister has already indicated that she would seek, but it would prevent a scenario where the government, or indeed this House via an amendment, could elect for a very long extension, which might then, in fact, lead effectively to the revocation of Article 50 and our never leaving. I will give way.
To the honourable gentleman for giving way. I just wanted to pick up a comment he made a moment ago. As I understand the purpose of his two amendments, the second one is to delete subsections 6 and 7, and the first is to put a maximum length of extension to the 30th of June. But subsection 5 remains, and on my reading of the bill, that would allow the House to amend the 30th of June date that he is seeking to insist is the latest date that the Prime Minister could put in the motion provided for under subsection 2. Can he just clarify that that is indeed the result of his amendments?
Well, we've all had a little time to look at these, but my understanding is that by adding my amendment, that creates a maximum time limit, and that subsection 5 would then be subject to that, since it is subsection 3 that makes explicit reference to subsection 2, which is the motion that would be before the House. And so I think the consequence of my amendment would be that a limit of the 30th of June would be put in place, notwithstanding what is said in subsection 5.
For giving way. I mean, that would not be my interpretation, because subsection 5 says
If the motion in the form set out in subsection 2 for the purposes of subsection 1 is agreed to with an amendment, then that is the date the Prime Minister was asked for. That clearly shows that the motion the Prime Minister would move is capable of amendment, and therefore, if the House decided to put an alternative date to the 30th of June, that is the one that the Prime Minister would have to seek in her discussions with the European Union.
I don't agree, because subsection 3, as amended, if my Amendment 20 is accepted, would mean that it would not be possible to have an amendment in the date provided for in subsection 2 that went beyond the 30th of June, because subsection 3 is explicit that it should not be later than the 30th of June 2019.
I think there are different giving way. If I can, without wishing to cause a rock with my friend from Leeds, I would agree with the interpretation of the other gentleman over there, that essentially, as has always been the case in this place, a motion cannot trump legislation. So if the motion has a date later than that on the face of the bill, the face of the bill it takes primacy. And so whilst I understand the misinterpretation that my friend may have, I would interpret the bill in the same way as the honourable gentleman over there.
We thank the honourable gentleman very much for his intervention, and I think for the honourable member's point to be valid, subsection 3 would not exist at all. And so, as subsection 3 is amended, as I've suggested with Amendment 20, I do believe that it would therefore change the terms under which subsection 2 could be exercised, and that would in turn have a direct impact on the reading of subsection 5. I will.
I'd like to just test his amendment slightly, because it's not dissent to an amendment that's been selected in my name. Can I ask how he picked the date of the 30th of June? Why that particular date gave clarity to what he wishes to achieve?
Well, the honourable lady makes an important point, and I think I chose that date primarily because initially the Prime Minister suggested that she might seek a short extension until, say, June. Now, we all recognise that there is an issue with the European elections, and that if we were to go for a long extension, we would in this country have to consider whether we would be fighting those European elections and start fielding candidates for those. My own view is that by selecting a date for the 30th of June as a maximum, it does not preclude the government to say that they themselves would choose a date of, say, the 22nd of May. But if, for instance, it were thought necessary to go slightly longer, to go to the 30th of June, then it would, in those circumstances, be open to all of the parties, both the UK government but also the European Union, to have a conversation about whether or not it were indeed necessary to hold European elections in this country, given that it was only a short extension going for another month. And I'm aware that within the British Civil Service, consideration has been given to whether, in a short-term interim arrangement, it might be possible to send delegates from this House to represent the UK in the European Parliament. I will give way.
Isn't it the fact, though, that the European Union has made absolutely clear that the maximum extension that is available, and this has to be agreed if it's an extension as opposed to a revocation, is May the 22nd, unless there is a long extension of potentially 21 months or a long period. And in those circumstances, we would have to fight the European elections. So if his proposal was agreed, it is unlikely to be accepted by the European Union. And that could, in a way, lead to us crashing out with no deal.
I don't know why it's been allowed.
I'd simply say to the honourable gentleman that my Amendment 20 is generous to the government. It gives them the option, should they believe it necessary under EU law, to set under subsection 2 a date that is indeed the 22nd of May. But if it were felt necessary by all the parties, including the European Union, that in order to get a withdrawal agreement over the line, it needed that extra month that went beyond May, I personally think it is not beyond the wit of man to be able to do so and to have arrangements in place that would mean it would not be necessary for us to hold European elections in this country. And I would further contend that one of the biggest problems we've had throughout this negotiation is a tendency to get over-obsessed by the intricacy of so-called European law. My right honourable friend, the Secretary of State in the Department for Environment and Rural Affairs, recently told me about a meeting that he had had during a discussion with ministers from other European countries, and they simply made the point that if the politics requires it, it is always possible to amend or disapply European law for the short term, should that be necessary and expedient for all the parties to get a sensible resolution to a difficult crisis. I will give it.
The honourable gentleman for giving way, but with respect, I think you'll find that it is in treaty, in international law, that if you are a citizen of the EU and there are elections, you are entitled to be able to vote in those elections and to be represented in the European Parliament. So, whilst I agree that where there's a will, there's a way often, especially with the European Union, on this matter, to my understanding, it would require a change of an international treaty to extend to June the 30th without those elections, and that's why the EU is very keen that if it is extended, it would be much longer.
Exactly. Well, I think the Honourable Lady is making a point that I understand, but I would simply say this. Sweden, unlike Denmark and the UK, never had an opt-out from joining the euro. But they did indeed have a referendum result that decided they should not join the euro. And as a result, technically speaking, Sweden has been in breach of international law and European law ever since they never had an opt-out from the euro. And it's simply the case that for a period of, well, we're talking 1 month here under my amendment, if it were felt necessary, that we would find a way of extending our membership in order to get the withdrawal agreement through. I can't believe that it's beyond the wit of man for that to be accommodated, notwithstanding what might be said in some treaty or other. It would not be the first time that the European Union has done this. But I would also make a point to the Honourable Lady, as I pointed out earlier, if the government believes that the treaties are indeed inviolable and cannot be changed even for a period of 4 weeks, well, then it's open to them to select a date of the 22nd of May. My amendment is generous to the government, and it gives them the option, should it be possible to get agreement with the European Union and other parties, to go for a date that is slightly longer. I will give it.
Yeah, I think my honourable friend is, if I can assist, really. This question of the date has been a vexed question because we are obviously not in favour of any extension. But coming out of the Commission, they tend to think the 22nd of May is a key date. But having had a meeting with Guy Verhofstadt in Brussels, he tends to recognise the 30th as a bit of a cut-off date. So I think we are into a period of ambiguity. And so I think my friend is right to give that sort of latitude.
Thank my honourable friend for that. And you know, one of the problems with this whole negotiation is getting hung up over some clause or other in some EU treaty, when there's a much bigger dilemma that we all face, whether it's us or whether it's the European Union. And that is, how do we settle this political crisis? How do we find a resolution to this dispute and achieve a reconciliation in our country and achieve an outcome to this debate that can settle the Brexit argument, deliver the referendum result from 2016, but nevertheless, and I will give it.
Does the honourable gentleman for giving way, but doesn't the bill as drafted give the Prime Minister, and I find myself surprised at myself saying this, the flexibility to discuss with opposition parties and come to a conclusion on what is the best date for the interest of achieving the very objectives the honourable gentleman has set?
Yes, but it does so through a bill, and it gives the Prime Minister the opportunity, yes, to make her case to Parliament, but without any constraint on that at all. And given that this is a very novel legal approach, a rushed piece of legislation, a bill being driven through the House in 1 day, I think we should be cautious about the scope on which we attach to that bill. And to attach to that bill, effectively, an ability to go for a very long extension of several years, potentially 5 years if Parliament decided that's what they wanted, I think is worthy of further deliberation. And therefore, I think, given that this is a rushed piece of legislation, we should be cautious about the scope that we attach to it. And I will give it.
Well, I thank the honourable member for giving way, and I understand his perspective on the politics of this and the policy outcome, which would be effectively a limit on the 30th of June in terms of what this bill could achieve. But could I just clarify with him, because I think my interpretation of his amendment is more in line with the Right Honourable Member, my honourable friend, the member for Leeds Central, because his Amendment 20 would change the date or refer to a date of no later than the 30th of June 2019 in subsection 3. But it does seem to me that that is superseded by subsection 5, and if he wanted to achieve the outcome that is intended, that he should have tabled a further amendment to another date in subsection 5, which he hasn't done, and therefore actually would override and be able to amend a date in a motion tabled under subsection 2.
I strongly disagree with the Honourable Lady on her reading of this, since subsection 3 sets out the terms in which anything can be offered under subsection 2. And in subsection 3 we place a clear limit with Amendment 20 that should be the 30th of June. And subsection 5 then says, if the motion in the form set out in subsection 2 for the purposes of subsection 1 is agreed to, then an amendment to change the debate and so on and so forth. The issue that I would have is that subsection 3 itself says that the date has a time limit. So it would not be legally possible under subsection 2 to have a date that contradicted with the requirements set out in subsection 3. That is my contention, and I disagree. I think if the Honourable Lady and the member for Leeds Central were right, they would not have had subsection 3 at all. I will be.
The Honourable Gentleman made a remark which goes to the question of the money resolution that I raised earlier. He said, and I'm going to take his word for it, because no doubt as a recently former minister, he followed this very carefully, it could be that the date in question could be, the extension could be as much as 5 years. Now, if he mentioned that and thinks about it, multiply 5 by £18 billion of taxpayers' money, which is the amount that we pay out every year in gross contributions to the European Union. That works out at £90 billion. Now, that is his assessment, and I'm simply asking him, effectively to ask the Minister vicariously, if he is aware that this bill could actually cost £90 billion of taxpayers' money. I think, hopefully, the media will pick up on that.
Well, I think my right honourable friend makes a very important point, and that is why, in my view, given the rush nature of this bill, and we all understand the reasons for that, it is necessary, therefore, to place constraints on the scope in which it can be operated to limit precisely the kind of financial liabilities that my right honourable friend alludes to. And indeed, my contention, Madam Chairman, would be that this would be something that if there were indeed a suggestion that we should have a longer extension going beyond the 30th of June, going maybe for 21 months or 2 years or even longer, well then that should be surely the subject matter of another bill. Since, after all, we've demonstrated today that we can introduce bills of this sort in short order. And if the future of this House is very much that any types of decisions of this sort will indeed require a bill, and that can be delivered within a day's debate on the floor of the House, surely it is right that we constrain and restrict the scope of this particular bill to deliver us through this immediate crisis that we face, and it is undoubtedly a crisis, but nevertheless keep open the option that should this House wish to consider a longer extension, it would be able to do so. I will give it.
I thank the honourable member for giving way. He's being generous with his interventions. Perhaps I could just put this back to the honourable gentleman. I do fear that what he may not still fear that the interpretation of this is not what he intends, and this isn't about the rights or wrongs of the date, but just what his amendment will do, which seems to me to be putting a cap and an end date on what the Prime Minister could put forward to the House, but not putting a cap or an end date on an amendment that the House could seek to her motion. And that's where I think there is a differentiation between subsection 3 and subsection 5.
That's correct.
My view is that none of this bill prevents the Prime Minister from still exercising her powers, her royal prerogative powers outside this bill. So if it were the case that the government were to decide to recommend to this House and to decide that it should go for a longer extension, and it had a clear rationale for doing so, I still think it would be able to do so outside of the scope of this bill. What this bill doesn't do, in my view, is say that the prerogative powers of the executive are vanquished on all areas for all time. Instead, what it seeks to do is to establish an ability for the House on this particular narrow issue to have an ability to set a motion. So I don't think anything in this bill constrains the ability to still exercise, the government to still exercise its prerogative powers. What it clearly does is require them to exercise those prerogative powers in accordance with this bill, if they are indeed exercised in response to motions passed by this House. So I don't accept that. I will.
I'm grateful, because I've been wondering about that. He says that this motion mandates, or effectively mandates, but is that right? Does he agree with my reading? That effectively under subsection 2, this House is simply agreeing that the Prime Minister is seeking an extension. It doesn't mandate or order it. And doesn't that again make a nonsense of this swift drafting on such an important issue?
Well, look, there will always be issues when legislation of this sort is drafted, and this is very unorthodox legislation, very unusual type of bill, and that is why the two amendments I've sought to put down just seek to place really some restrictions on the scope in which these powers can be exercised. I turn now, Madam Chairman, to Amendment 21, which is really quite simply to delete subsections 6 and 7 altogether. And these are really the... I will give it.
Lady Winton, I'd just like to ask on the point of order whether it is possible for us to establish, given the complete rubbish that this bill contains, whether it is possible for us to find out who drafted it. Was it drafted by Parliamentary Council, or was it drafted by some ad hoc person? Because it's really quite important.
I understand that was a point of order. Is that right?
In answer to my question, after all, the government and the House authorities in the House are responsible for bringing forward bills. We've had nothing but trouble since these proceedings began, both on the amendments and otherwise. And I'm not criticising. I know that there was a tremendous amount of speed, which is the reason why this bill is so inappropriate. But having said that, the question really is, what are we trying to legislate for? That's what these committee proceedings are for. And I am beginning to observe that this bill is complete rubbish. And therefore, it's very difficult and more important for us to know, who drafted it.
I think the honourable gentleman is expressing an opinion, a debatable opinion about the bill. The actual drafting of it, the Public Bill Office is always available to advise members on the drafting of the bill. I think we'll leave it there. George Eustace.
Thank you, Madam Chairman. And can I just put on the record, I have enormous respect for my right honourable friend, the member for West Dorset. And I do appreciate that all of these amendments that he's put down, he is trying to deal with an incredibly difficult and complex situation that we face as a country. And I, from the very time I was involved with the party, have worked with him closely. He has been the anchorman for several leaderships in the Conservative Party. And whatever differences honourable members on this might have, he deserves the respect of all members on this side of the House. But I turn now to my Amendment 21, which does require the deletion of subsections 6 and 7 of Clause 1. And these two subsections together make provision for the House to consider a counter-offer from the European Union. That is to say, if the Prime Minister were to seek an extension that went up until the 30th of June 2019, and the European Union were to make a counter-offer. The question arises, what should happen next? And, Madam Chairman, my contention is that what should happen next is that the government, at that point, should bring back its own proposals to the House, and that if this House at that stage felt that it wanted to bind the hands of the government in terms of what should happen next, well, that would be a matter, in my view, surely for a future bill, given that we've demonstrated our ability today to pass legislation in a speedy and efficient fashion. I'll give way to my right hand.
My honourable friend, and grateful also for his kind remarks. I really wonder, though, whether he means to remove subsections 6 and 7, if that is the intent that he has. The fact is that under the prerogative power, if the Prime Minister were to go to the European Council, as he envisages, with a request for something less than 30th of June, and if they were to say, which would not suit, I think, him, and might well not suit me, that there should be a 21-month extension, for example, there is actually nothing to prevent the Prime Minister simply, as we stand here at the moment, not having passed this bill, to prevent the Prime Minister accepting that. It would be necessary, of course, to pass a statutory instrument in this House, as things currently stand, to reconcile UK law with the then international law position by changing the exit day in the Withdrawal Act 2018. But the House wouldn't have much choice about that matter, because it would be out of kilter with international law if it didn't make the change, as we discovered when the original SI was put. And, of course, when the Prime Minister made the original application, she did not seek the approval of the House. She was able to make it perfectly properly under the prerogative power. So, if he removes section 6 and 7, subsection 6 and 7, the effect is not, as he might imagine, to stop the Prime Minister doing something which he would regard as a mischief, namely accepting then and there a very long extension, but rather to enable her to continue to enable her to do so, as she is currently able.
My right honourable friend, I'm sure, is aware of the reason I resigned from the government, which is that I generally believe that it is right that the executive, as a general rule, should retain control of these types of decisions, and that if we get into a position where 650 or so MPs here are trying to participate in a negotiation with the European Union, we are in quite a bit of trouble, in my view. And I think, therefore, I would say two things. First of all, it's a question of a balance of risk. And my view is that confronted with an unpalatable decision, a demand for, say, a 2-year extension from the European Union as the only deal on offer, as it were, I would rather still, having resigned from the government, I would still rather take my chances with the Cabinet to show some backbone in those situations than I would take the risk with this House. It is as simple and as honest as I can be about the reason. I will give it.
In that case, I withdraw what I was saying in the sense that he is achieving exactly what he wants. He's leaving the Prime Minister with untrammelled prerogative power, and of course that's a perfectly possible choice to make.
Well, of course, it's very good that we agree on something, but I do, I fear, Madam Chairman, that what would actually happen if we are not careful is that the European Union would make appalling demands for financial contributions, for a long extension, and that this House, when it comes down to it, would not have the courage to resist that, having already indicated that it lacks the courage to leave without a deal, which I believe was a mistake. I didn't want to leave with no deal. I would like there to be an orderly withdrawal with an agreement, but I believe that once you take no deal off the table, you fundamentally undermine your position. I will.
I'm very grateful to my right honourable friend, and following on from the intervention from my neighbour and my right honourable friend, is it not the case that in any event, notwithstanding whatever is in the bill, the Prime Minister still retains the prerogative power? So the bill may encourage or seek that the Prime Minister asks for a certain date, but in fact there's nothing stopping the Prime Minister adopting a parallel track, or indeed at making a third request. So in any event, even if this bill is passed unamended, which clearly my right honourable friend does not want to happen, in any event, the Prime Minister could still chart her own course.
I think the honourable gentleman makes a good point, but I do think the way that this bill is crafted, linking as it does in Clause 1, subsection 2, back to the European Withdrawal Act, it does have legal force and does bind the hands and constrain the ability of the government to exercise those prerogative powers. And that is why the two amendments that I put down, except that this has passed second reading, except therefore that this House has voted to constrain those prerogative powers, but nevertheless then goes on to place constraints on the scope under which this House can exercise those powers, and he's absolutely right that outside of the scope, where Amendments 20 and 21 agreed, it would still be open to the government to use its prerogative powers to make agreements beyond that. I will give way to my Russian friend.
Grateful, and I apologise for continuing a triangular discussion this way, but in response to my honourable friend's point, I think the answer actually is no. The prerogative power is subject to statutory limitation. This bill would limit statutorily this prerogative power in that respect, and we can know that for sure because that is the view of the government lawyers, and you can tell that by looking at Government Amendment 22, where they seek to reintroduce the prerogative power, because the government recognises, the discussion I've been having with the government during the course of the day, that the bill currently limits the prerogative power. So there is a choice for the House here to be. And we may obviously take different views about how to make this choice, but just as a matter of plain fact, there is a choice to be made here between the position that our honourable friend is advocating, which is one of reinstating the full prerogative power, which could otherwise be achieved by Government Amendment 22. There are two ways to do it. Or, as I would prefer, to limit that prerogative power by statute so that the House has the ability to constrain to some degree what it is that the Prime Minister accepts by way of an extension from the EU.
Well, thank you. And I think my right honourable friend's comments were directed at the previous intervention, perhaps rather than directly at me, so I won't, I won't get engaged in a discussion on that. In conclusion, Madam Chairman, I just wanted to effectively say that in terms of the provisions for subsection 6 and 7, the question would still remain, what happens in those situations if there were to be a counter-offer from the European Union? And my contention is that at that point should be a matter for the government to bring before the House in a statement and to be challenged in the usual way. And if this House at that point felt unsatisfied with the proposal being brought by the government, then I believe it would still be open to them at that point to launch just such an initiative as we've seen today, to introduce a further bill, to place a further constraint on the government, and maybe to require the government to accept a counter-offer, for instance, of a 2-year extension, and for us to have a fuller and maybe a longer and more considered debate about what, in my view, would be a really big decision, because a long extension of maybe 2 years means that we would have gone 5 years since the first referendum and achieved nothing at all. And I think the risk at that point of not leaving the European Union at all, and the risk of us ending up in arguments about a second referendum, would grow. And I believe that that decision to go for a long extension is a very big decision, and one that would warrant, in my view, a separate bill and a separate, much longer, much more detailed discussion.
Hanson.
Thank you, Madam Chairman. I hope the House will bear with me, because obviously the amendments have been tabled very recently, but I do think they deserve exploration. And I want to first of all support the amendments, which are drafting amendments, in the name of my honourable friend for Pontefract, Normanton and Castleford, and the right honourable gentleman for Dorset West, because both are drafting amendments. And as members will know, having served on probably nearly 45 to 50 bill committees in my time in this House, governments do bring forward drafting amendments during the course of debates. They do make changes. There are opportunities in the House of Lords when this bill is considered there for further drafting amendments. But the principle of what my right honourable friend and the right honourable gentleman are trying to achieve is that of a no-deal scenario being ruled out. And that is vital for this House. Now, the bill, as it currently stands, leaves in Clause 1, subsection 2, the date of the decision on that leaving date for the House of Commons to have a measure brought back by the Prime Minister open. And the amendments which I want to speak against today indicate there should be definitive dates for the closure of that discussion by the Prime Minister. Now, as I said in an intervention to the member for Falmouth and Camborne, I find myself in a very strange position today, in the sense that I want to give the Prime Minister maximum flexibility to achieve the objectives that will join this House together with the British people in achieving a deal which will satisfy the British people, the government and indeed members of the opposition. My constituency voted leave. I personally voted remain. There is a settlement to be made there, and the Prime Minister needs maximum flexibility in order to make that settlement. But what this House has been very clear on is that no deal should not be an option, and the bill in the name of my right honourable friend and the right honourable member for Dorset West seeks to do just that. Now, the amendments that are in the names of honourable members opposite, including the member for Falmouth and Camborne, setting a date of the 30th of June, or the amendment in the name of the honourable member for St Albans, setting a date of the 22nd of May, or indeed Amendment 6 in the name of the right honourable member or the honourable member for Stone, which asks for the Northern Ireland Assembly to concur to a settlement prior to any settlement being agreed, when at the moment, for reasons that I find disappointing, the Northern Ireland Assembly doesn't meet, so there is no definitive date in the right honourable gentleman for Stone's proposal to date. I think all of those do something which, again, I find myself in a strange position saying today. They are restricting the Prime Minister's opportunity to make a difference and to achieve a deal in this House. I'll just give way to the honourable gentleman, my honourable friend, and then the honourable lady.
Oh, sorry.
My honourable friend's making an excellent speech. Isn't it also true that the Prime Minister has invited the Leader of the Opposition to discuss the political declaration and withdrawal agreement, and we are in the middle of this process, and particularly the new clauses from the right honourable member for Stone are in effect curtailing those discussions, and should we not pass this bill cleanly to allow that process to maximise itself?
Well, I accept fully what my honourable friend has said. In a moment, I accept fully what my honourable friend has said, in the sense that the Leader of the Opposition has this very day met with the Prime Minister at her request, invited into Downing Street at her request, with my right honourable friend for Holborn and St Pancras North, to put positions on a customs union, a single market, potentially even a confirmatory vote, for the Prime Minister to consider. And yet, the no-deal bill that is before us today fixes a date which is in the future, to give the flexibility for that process to take its time. Now, the flexibility that has been given in the amendments down today, which I've only had a cursory look at, are the 30th of June and the 22nd of May. Now, again, let me just say, before I give way to the honourable lady, I recognise there is a problem, and the European elections are the elephant in the room. Let me just say again, with regard to the Northern Ireland Assembly, we passed legislation when I was the Minister in Northern Ireland to establish elections or not establish elections on a regular basis within a day or 2 days. The Prime Minister is going next week to the European Council on April the 10th to discuss what this House has decided. This House may well decide that my right honourable friend's bill is one with an open date we accept, or he could fetter that discussion by putting a date in place. I want to give the Prime Minister maximum flexibility.
Gentleman given way, and obviously I will be speaking to my amendment, but can I just say to him the flexibility he desires, because obviously I don't think he means flexibility to deny Brexit altogether, given he's got a leave constituency. The point of my amendment, which I hope he might look at a little more closely, is to stop the Prime Minister agreeing anything that may be unacceptable to the House. So the date picked is the date that's currently being discussed by the European Union. And therefore, should the Prime Minister agree a date that the House would find unacceptable, she'd have to come back and suggest it to the House. Rather than being able to do what she can at the moment, and other members have mentioned it, she can just pick a date that this House may find unacceptable. And that's the point of this, on that particular matter.
That's an interesting point, and again, the amendments are fresh. I'm looking at them fresh. But the key thing for me is that this House has shown in the last 3 months and in the last 2 weeks and 3 weeks certainly that it will not accept unilaterally what the Prime Minister wants to bring back to this House. And this House has many ways in which it can check the executive in its decisions. The simple point I make Madam Chairman, is that for my constituency in North Wales, the manufacturing businesses that make cars have said no deal will cost £10 million per day for those businesses. The farmers who produce lamb will not be able to export because of a no-deal scenario. The Airbus firm that makes the best planes in the world will have difficulties exporting because of a no-deal scenario. The Cabinet Office has said the prices will rise. It's not me, that's the Cabinet Office, the government's own determination. My right honourable friend from Normanton, Pontefract and Castleford mentioned the European arrest warrant, SIS2, the agreements of sharing information. We don't know whether those will exist in the form they are now if a no-deal scenario goes ahead. This very morning, the Secretary of State for Justice and yesterday the Solicitor General in the Justice Committee, on which I said, both could not give assurances about the future relationship on important matters of security and justice if a no-deal scenario goes ahead. I'll give way to the honourable gentleman.
I do thank the honourable member for giving way. He makes a very compelling case as to the concerns that people have about what may happen in a Brexit without a withdrawal agreement. But would he also concede that the withdrawal agreement has been, on many occasions, explained to us by the European Union as being basically now a hermetically sealed box? And many of the things that he discusses in terms of the future relationship, in terms of trading, in terms of all these things, are encompassed in the political declaration, which cannot be binding, and we've been told that many, many times. And I genuinely fail to understand why, if he's so concerned about leaving without an agreement, he does not just vote for the withdrawal agreement and then set about making his case for what should be in the political declaration, which cannot be binding yet until we have formally left the European Union.
Due respect to the honourable gentleman, we've sort of had that argument over the last 3 or 4 weeks, and the House of Commons has spoken, and that is why his leader, his Prime Minister, has invited my party leader to discuss what are the next steps. And all I'm saying to him and to other members today is that the fettering of the process by some of these dates which have been put in, and I wait to hear what the Minister says about his amendments because we need to be clear on those, but the fettering of those dates caused great difficulty to the objective my right honourable friend has got, which is to make sure that when the date comes next week, whatever happens with our discussions, we have a date which is determined by the Prime Minister as to when we leave with a scenario, rather than have a no-deal crash out in the future. I'll give way to the honourable lady, then the honourable gentleman, then I want to try and complete my remarks to allow others to finish.
Just because the honourable gentleman has been saying he would like to have certainty, and I completely accept the worries that are surrounding maybe no deal and not knowing what's going on. That is crucial for businesses. But how is he going to feel if one of these amendments restricting exactly how long the Prime Minister can actually agree on her own, how is he going to feel if the Prime Minister comes back and says, I've accepted, because I am able to, a 2-year extension, and all that uncertainty then over what happens is magnified for 2 years with his constituents?
Let me say to the honourable lady that we've got to have some trust in this process now. This House has to compromise and have some trust. The Prime Minister has made a genuine offer to my right honourable friend, the Leader of the Opposition, much to my surprise, to get herself, and indeed, with due respect to the lady, the Conservative Party out of a giant hole. Let's give the Prime Minister that fettering here to determine the date, because that is the important matter in discussing the objectives that we've got today. I'll give way to the honourable gentleman.
My friend for giving way, and in particular the points he makes about Amendment 6. Would you not agree with me that as opposed to representing a sincere interest and respect for the devolved administrations, it is rather a very clever way of preventing the quick and effective enactment of this bill?
Let me say to the honourable gentleman, he will know that I want the Welsh Assembly and the Welsh Government, and I want the Scottish Parliament to be consulted, to have a say, and hopefully to join in with the settlement that makes the situation for my constituents and the country as a whole a much more calm and better place than it is currently now, in whatever form that takes. But he will know, and I'm pleased to see the honourable lady in her place today, that she will know that this is a block in the event of the Assembly not being restored. And it's not even a block, with due respect to the honourable lady for the moment, it's not even a block in relation to Northern Ireland government. It's a block even if direct rule was restored, for example. It says the Northern Ireland Assembly. So we have no definitive date for that. And whilst I want it to happen tomorrow, because it's been 12 years since I was the last direct rule minister in Northern Ireland. I'd like to see the Assembly restored. Ultimately, it's not at the moment. Give way to the Honourable Lady.
Very grateful indeed to the Right Honourable Gentleman for allowing me to do. Thank you, Madam Chairman. Yes, the Right Honourable Gentleman has made the point that, in fact, the Northern Ireland Assembly has not been sitting since January of 2017, and there is no expectation that the Assembly will be sitting any day soon. And further to that point, the Right Honourable Gentleman, as a former Director of the Minister in Northern Ireland, will know that it would be an unmitigated disaster for Northern Ireland if this country were to leave without a deal. An unmitigated disaster in terms of our security. He will know all about the threat from dissident Republicans, and he will also know that Sinn Féin would use a no-deal Brexit to campaign for a border poll to take Northern Ireland out of the United Kingdom and into United Ireland.
Well, the Honourable Lady for Down North speaks, North Down, sorry, speaks much more sense about this matter than I can possibly do, because she is up to date on the situation. But it's clear to me that, let me just take the one example that my right honourable friend for Normanton, Pontefract and Castleford mentioned, the Northern Ireland arrest, the arrest warrant, European arrest warrant. Without an arrest warrant, we use the arrest warrant on numerous occasions to bring people who have committed crimes in the Republic into Northern Ireland, and vice versa. If that is not in place, in a moment, let me just finish the point. If that is not in place, and under a no-deal scenario that wouldn't be in place, it would be a poorer situation, we have no clarity on that whatsoever, then the security of Northern Ireland would be in a worse place than it is now, and I'm not prepared to vote for that.
The honourable gentleman just referred to the arrest warrant. I have to say to him that I am well aware that in the county of Staffordshire there was a person who was actually convicted under an arrest warrant of murder. In fact, it transpired, under the arrest warrant that is, he was convicted in his absence. He was actually working in Staffordshire, and he was actually found to have been not guilty as a result of the fact that he was actually working in a restaurant at the time in England when he's supposed to have committed the murder in Italy.
We can't get away with that. People are found innocent or guilty on different occasions. The ultimate situation is, if somebody's done something and they've been convicted, and an arrest warrant goes out to a country in the European Union at the moment, that individual will come back speedily to face justice, to face imprisonment, to face trial, or to face conviction. And any change in that arrest warrant procedure will ensure that that is a slower, more cumbersome, more clunkier procedure. If he wants to look at that, let him just look at what the Deputy Chief Constable of Northern Ireland said only on this weekend. He said it would be clunkier, more difficult, more bureaucratic, slower, and would lead to a worse position than we have now. So I don't want to take lessons, with due respect to the gentleman, on the arrest warrant. The arrest warrant is about protecting my constituents, protecting citizens in this country, and ensuring people who are criminals are brought to justice. And if we have a no-deal scenario, which this bill is trying to stop, that will be more difficult to make that happen in society as a whole. So, Madam Chairman, I've said my piece on this. I hope that honourable and right honourable members opposite will reflect on the position here. This bill is about protecting us against no deal. It's about ensuring that we secure a positive future on the range of issues: agriculture, business, transport, crime, security. And any fettering of the Prime Minister's discretion on this will be more difficult to achieve the consensus that I understand the Prime Minister is trying to achieve with my right honourable friend, the Leader of the Opposition, to ensure that we achieve a better settlement in this House than we've currently managed to perform on in the last few weeks and months.
Mrs Anne May.
Very much, Madam Deputy Chairman. I'd like to speak to the amendment that's down in my name, and it has similar threads associated with it as the honourable member who spoke earlier for Camborne and Redruth. I was quite horrified when I read this very brief bill that was coming before the House, because it mandates the Prime Minister to seek an extension, but there is no date associated with that extension, and that's been touched on by various other members of this House. And on top of that, as we know, enshrined in Article 50 was the date that we left on the 29th of March. The Prime Minister, quite within her right, I think the honourable member for West Dorset said it was her untrammelled prerogative, decided, when she went into her negotiations, that she would accept a new date offered to her by the European Union all agreed within a room that she was not participating in for the debate of the date, and she accepted a date that was not of her choosing. Now, my concern is that whatever date is thought to be the right amount of time by this House is a date that, if the Prime Minister is not fettered, as the previous speaker has just spoken to, if the Prime Minister is not fettered, she is quite within her rights, and nobody here is seeking to, in any way, shape or form, curtail those rights. She's quite within her rights to accept another date that may well be offered to her, and may be the only date that is on offer. So that whatever date this House may wish to see happen, for whatever reasons or purposes that are given associated with that date, the Prime Minister is quite within her rights to accept or reject a date that is on offer from the European Union. Now, I find that incredibly worrying. Depending on which side of the argument honourable members find themselves, they either might find themselves with the Prime Minister seeking a date in line with the House's instructions, but actually she doesn't have to agree the date, even if they say that she can have it. That would be a rather bizarre scenario, but that is actually not stopped by this bill. So whatever date the House fixed on could, in theory, only be asked for, but then be rejected. The other side that worries me far more is that the Prime Minister goes along with a date, as unspecified by this House, without the justification yet to associate it with that date, goes along and is offered a date, let's say, 2 years in the future. At that point, I would suggest that most honourable members in this House would have severe concerns about the legitimacy of whatever was being agreed by the Prime Minister or any of us in this House with a date set so far off in the future. Now, the amendment that is down in my name, and that of, I think it's 21 other honourable members in this House, simply points to the date that is already a date that's been accepted by the European Union at their own suggestion. I know Guy Verhofstadt actually came to the date at the end of June, but actually is a date that's been suggested on many occasions by the European Union as a date that they would be comfortable with extending to. It is also a date that means that we are not obliging ourselves by default to have to fight in European elections. It means that the Prime Minister can accept the date offered to her, which is to the 22nd, but she cannot arbitrarily accept any other date without bringing that date back to the House and discussing with the House if the date that is being offered meets what the House wishes to achieve. And I think it's incredibly important, whilst I can say that the member who spoke before me that talked about not tying the Prime Minister's hands, I actually think on this occasion, if the House truly wishes to shape the next phase of this, and I really don't like this process, but I'm trying to look at this constructively, it's incredibly important that the Prime Minister does not have carte blanche to sit in a room over in Brussels and then meekly accept a date and then come back to this House, and that date then will be fixed. It won't be a date that this House can alter. So I have picked the date of the 22nd, because that is a date that she can agree anything up until that point. But after that point, a date that we are all familiar with, we do not have the Prime Minister accepting a date that may end up coming here and not finding favour. We are then back in long grass terms. We are back arguing about the date. We're back arguing ad infinitum to the great uncertainty for many businesses who feel that what's going on here today is beyond a farce. Others that have got a far better brain than mine in terms of a legal brain, and I have no qualifications whatsoever, are looking at this line by line and saying it's shoddily drafted, it's poorly drafted, it doesn't stand up to scrutiny. And the argument that comes back, and I've heard it a few times this afternoon, is, oh, well, we haven't had a lot of time, and this is to stop no deal. My suggestion is my amendment certainly doesn't do anything to harm the objectives of this bill. What it does do is give this bill belt and braces to ensure that the Prime Minister, who everyone says let's give some latitude and trust to, the Prime Minister is not able to accept something that is certainly beyond the wishes and scope of this House or what the people who voted to leave the European wanted. And I hope it's given serious consideration, since we're supposed to be trying to engage constructively with this process now. We are in a cross-party consensual way looking at trying to get something through. I would be far more comfortable that the Prime Minister was not allowed free rein, untrammelled prerogative, as the Honourable Member for West Dorset said, because I think the House might have observed we've already tried that and it's not got us terribly far. So I would actually like to say, please reconsider this particular amendment. It's very small, it doesn't stop anything. It simply stops maybe what maybe some members here tonight haven't thought through too well, is the date. I certainly shall do.
I'm very grateful to my honourable friend for giving way, and I applaud her ingenuity, and I believe I'm minded to support her this evening, and I hope that she does push it to a vote. But can I ask her about another extension? Because the bill as drafted doesn't in fact mandate or order under subsection 2 the Prime Minister to do anything. That comes later on in the bill. But there's no time frame given either. So my honourable friend has mentioned a time frame up to the 22nd of May, but as drafted, this bill effectively gives no specified time period within which the Prime Minister needs to seek any extension in any event.
My honourable friend is absolutely right. And it was the clerks that were very helpful when I was trying to draft this, because I said, surely we can't have this open-ended situation. And the clerks very helpfully said to me that the bill can say what it likes, but at the moment the Prime Minister, in the untrammelled way that the Honourable Member for West Dorset said, can do what she likes. And that is the situation here. We are in fact sending off a Prime Minister who will be reluctant to want to deliver what is on this particular order paper. So, whilst the bill is supposed to be incredibly flawed, what I don't want it to be, as we knew from the Gina Miller challenge, is a nightmare going through the courts. Exactly. Our businesses deserve better than to have a piece of cobbled-together legislation that is rammed through, and I gather is going to be rammed through at the other end of the House as well, just to make sure that we avoid no deal. Can I say to the honourable members, have they not done some adding up recently, and other right honourable members? This House is the tail that is now wagging the dog. I don't think there's any pretence on this side of the House that this is going to be an easy ride. Not for this stage, not for the next stage, or any other stages coming down the road. Which is why, if there are fears from the members opposite, who seem to be able to exercise an awful lot more muscle than we can on this side of the House, if there are fears from the members opposite about the political agreement, they have the whip hand over the government, in effect. Because this House does not, in true nature, really desire to leave, the House will have masses of opportunities over the coming months to ensure that the political agreement is shaped in a fashion that they would like. It is the one thing that the European Union has said, oh, we can open that, no trouble. What they won't open is the withdrawal agreement. And indeed, many of the things that this House wishes to achieve will need a withdrawal agreement. And that's why I reluctantly agreed to support the withdrawal agreement when it was separated off from the political arrangements. So this tonight is a very poor and badly drafted bill. I accept the reasons why, and I accept we're all scrabbling around to try and improve it. I am disappointed that the Lords may not have much time to consider any amendments that are passed here tonight. Please, I hope that there's not going to be a rubber stamp machine down the other end that says, doesn't matter, this bill's going through regardless. Because in all honesty, this bill is going to come back to haunt this House. This procedure that we've done today, if it ends up being a lawyer's charter and a nightmare going through the courts, will be something that does huge damage to our industries, because believe me, for every Gina Miller that's out there challenging to try and make sure that the public vote is really listened to in a proper legal fashion, there will be lawyers picking over this tonight saying it doesn't hold up and it doesn't stand up. So can we please ensure that there are sensible amendments here tonight? I would like to say that my amendment is sensible, in as much that the honourable member who spoke earlier from the independent group pointed out that the only date that the European Union has accepted is the 22nd of June. So I believe by putting that in here, we are actually picking a date that the European Union is comfortable with, and if they come up then with a different date that's not one thought up by this House, there is a security in the House of knowing she cannot unilaterally accept it. She must bring it back for your consideration. And if the House chooses to adopt it, fine. If the House says go back and try harder, fine. But there's a certainty in this House, and I hope this amendment will be passed by members whichever side of the argument they are on, because they will then know there won't be any jiggery-pokery, any clever amendments, clever dates, clever shiftings of time. The Prime Minister is obliged, under my amendment, to come back to the House with any new date, and she is not allowed to accept it without the House's will. Surely that's what this House wishes to achieve.
Tom Blake.
Thank you, Mr Deputy Speaker. First of all, I wanted to thank the member for Camborne and Redruth, who isn't in his place, for tabling his amendment, because it gives me an opportunity to speak against it. Now, what he's trying to do in his amendment is set this date of the 30th of June as a date beyond which the government cannot seek an extension. As the member for Ilford South said in an intervention, it's very clear that the European Union, if the UK wants to secure an extension beyond that date, is going to have to either embark on a general election, or going to have to embark on a people's vote, or go to them with a concrete, credible proposal that would mean that they were able to give a longer extension. And frankly, I don't think there is anything the government are going to be able to do that is going to enable them to hit not just the 22nd of May as a date, but indeed the 30th of June. So to preclude that possibility, I think, would be regrettable. And of course, as members will know, I imagine that every member here has been contacted by their local authority returning officer to confirm that they have all been asked to start the process of preparing for European elections. So whether the government like it or not, that is something that preparations are being made for at this very moment. And clearly the other thing that this amendment does, or would preclude, is, for instance, responding to business concerns. I mentioned earlier this evening the contact I'd had earlier today with businesses in the retail sector, who were absolutely adamant that leaving on the 12th of April would be catastrophic, leaving on the 22nd of May would be catastrophic, and indeed leaving on the 30th of June would not enable them to make the preparations that they need. And they were talking about at least until March 2020 in terms of an extension to enable them to prepare properly. So arbitrarily setting the 30th of June as a cut-off date, I think, would be extremely unhelpful. And of course, the other thing that would be extremely unhelpful in this respect, and I'm very grateful to Change UK members for tabling a cross-party amendment today around the people's vote. And of course, a cut-off date of the 30th of June would preclude a people's vote as well. I think people who've looked at the issue of the length of time that it would take to legislate for and then hold a people's vote campaign imagine or have estimated that something between around 20 weeks, 22 weeks would be the period of time that would be required for this to take place, and therefore having a cut-off date of the 30th of June would not enable that to happen. I'm very happy to give way.
Grateful. Even if these amendments were passed, the issue surely is that they would have to go with the government taking them to this European Council next week. And if there is a proposal to go for June the 30th, we know that that will not be acceptable because the European Union made that absolutely clear. So therefore, instead of resolving this issue before the European Council, if we adopt that amendment, then we would have to come back next week and we would have to be voting on the 11th or the 12th on the same matters yet again.
I thank him for that intervention, and I guess that would just add to this picture of chaos and confusion and running down the clock that's become a feature of this place in the last few months. I'm very happy to give way.
Can he not see the merit in what I'm saying, which is that that very scenario does not happen? It's just the Prime Minister can't agree the date. She brings the date back because I'm sure, given that he's just mentioned 20 weeks or so to get together a people's vote or whatever, each person's other agenda has a timescale associated with it. Therefore, if the Prime Minister is offered a date, surely she ought to bring it back to here and ensure that the date meets with whatever it is that people wish the date to achieve. We're doing it the other way round in this bill. We're sending her off with a date and mandating her to seek it. I don't see why. That seems ridiculous.
The bill doesn't, what the bill does specifically doesn't include a date in it, but actually enables the Prime Minister to go with a date that she has in effect inserted in the open brackets, ... closed brackets. So I think it is actually within the Prime Minister's control. But I think I'd just like to draw my remarks to a conclusion, really just to say that I'm not sure whether, and he's not here, so I wouldn't want to cast aspersions, but whether indeed it was the member for Camborne-Redruth's intention that this was here as a means of perhaps ending up with no deal, because seeking an extension to the 30th of June we know is not going to be well received by the European Union, because it doesn't actually enable anything to happen in the time that is left. But I hope that wasn't his intention. But clearly, we will, if this is pushed to a vote today, I will certainly be, and Liberal Democrats will be opposing it on the basis that it would preclude people's vote, and it's very clear around the country now that there is very, very strong appetite for such a vote to take place. Apart from...
Sir William Cash.
Thank you very much, Mr Deputy Speaker. Mr Speaker, they say those whom the gods wish to destroy, they first turn mad. I have to say, Mr Deputy Speaker, I have never seen a bill which is more likely to drive everybody mad than this one, particularly if it's enacted and it then has to be construed by the courts. I really am astonished at what rubbish it is. And I also just add, remember, Mr Deputy Speaker, that we were told that no deal is better than a bad deal. Just to offer an alternative, no bill is better than a bad bill. This is a classic case of hubris. This is a classic case of hubris. Overvaulting ambition in the hands of some amateur draftsman of producing consequences of vast import to the people of this country. I've already made the point, Madam Deputy Speaker, I've already made the point, having had an exchange with the member for Falmouth, I think his constituency is, that this bill, if he is right, that it could create an extension for 5 years, would cost the British taxpayer not less than £90 billion. Now, that's an awful lot of money for a private member's bill, and an awful lot of money for hubris, and an awful lot of madness which the gods will want to destroy. Certainly.
I'm very grateful to my old friend for giving way. In relation to that figure of £90 billion, has he received any advice recently as to whether that would or would not require a money resolution in relation to this bill?
I absolutely have. My honourable friend asked me whether I'd had any advice on the question of a money resolution for this bill. The Speaker has ruled on it, and therefore I take the view that if the Speaker has ruled, even if I'm unhappy with the ruling, it doesn't mean to say that I need to go into all the details. I could spend the next 20 minutes going through all the reasons why I believe it should have a money resolution, but I'm going to resist the temptation, because I really want to get on with the meat of this bill. The fact that other people know that it could cost as much as £90 billion is enough, I sort of thought, to alert a lot of people to a serious worry about whether they should vote for it, and I hope they would not vote for it. I'd start with my amendment which deals with Section 1. Section 1.1, Madam Deputy Speaker, is mandatory. It is a very important constitutional question as to whether or not Parliament can, in fact, direct a Prime Minister who must move a motion. It's just constitutionally ridiculous that something like that should be done. But the second thing is that the form of the motion, and this is to do with new clause 4, the form of the motion in section 1(2) of the bill is not mandatory in the sense that under it the House, quote, agrees for the purposes of section 2 to the PM seeking an extension. The motion, if passed, would permit the Prime Minister to seek the extension, but that, by itself, would not force her to ask for it. However, neither Section 1.4 nor Section 1.5 set any time limit to when the Prime Minister, quote, must seek an extension, nor how that is to be achieved. Is the time available to do all this? The answer is quite clearly no. Royal assent would be given, I presume, after it's been through the House of Lords. God knows what the House of Lords is going to make of this, because the reality is that the House of Lords has a Standing Order 72. And what have the government done? No doubt with the connivance, if that's not an inappropriate expression, of the member for West Dorset or Dorset West or whatever it is, because actually the House of Lords has its standing orders and they've just knocked out 72. I mean, this is an outrageous and completely unconstitutional act. But I'll give way to my honourable friend.
To my honourable friend for giving way, because he's questioned the ability of this Act to be enforced. And we put that question in my committee, the Constitutional Affairs Committee, to Lord Judge, the former Lord of Appeal. How would this be enforced, I asked, and he replied, and I quote, I think it could only be enforced politically by the House of Commons. Please do not think for one moment that anybody should be able to seek a judicial review. Not only would it be ludicrous for the judiciary to be involved in deciding a political question, but they would have a way out if anybody took that step by saying there is an alternative remedy, go back to the House of Commons. And that is the only way it could possibly be enforced, in my view. It would be up to the House. So isn't this a completely useless piece of legislation?
But it's rubbish as well. I see the honourable member for Beaconsfield has just come into the chamber. I'd like to ask him, if I may, if he's prepared to take an intervention, whether he drafted this. He drafted a lot of amendments during the passage of the withdrawal bill itself back in 2017 to 2018. And I did notice that quite a lot of them were so bad that they had to be junked. But I'd just like to know whether he drafted this bill.
I have to tell my honourable friend that I didn't draft the bill, but I think the bill is quite fit for purpose. And I also do notice that there are some amendments proposed to the bill by the government which relate back to exit day, which exactly echo the points which I made last summer in this House about the folly of putting exit bill fixed on the face of the EU Withdrawal Act.
So to continue, Mr. Speaker, at the very earliest, the motion cannot be carried till the 12th of April. This means that the Prime Minister is obliged at some stage to seek an extension, but she is not obliged to do so immediately. Unless she does so on the 12th of April and is agreed before the 11 p.m. that day, then the United Kingdom is out. Leave. Leave, leave, leave. Sections 1.6 and 1.7 are, I suppose, intended to deal with a situation where the European Council meets on the 10th of April. And it seems to volunteer to offer an extension to a certain date. I mentioned in an earlier intervention, I think it may have been a point of order, the question of the role of the European Council in all this. The reality is that the procedure that is being followed does put the ball back into the European Council's own court. They will be the ones who are most likely, if somebody isn't sensible enough to veto this extension, which they have the power to do, and I trust that one or other of them will, and maybe several of them. But having said that, the objection I have to this whole arrangement is contained in the European Scrutiny Committee report, which we put forward a year last March, a whole year and 1 month ago. And the reason that we created such grave concern was because the European Council, which is driving a lot of the negotiations, actually set out the terms of reference and the guidelines and the sequencing. And the fact that the government gave in on all that and supplicated and went along on bended knee to the European Council and ask them how much can you possibly let us get away with, what can we be allowed to do that you will agree with, all these absolutely monstrous negotiations conducted by Ollie Robbins, who appeared in front of my committee, and Sir Tim Barrow and others. The reality is that by submitting ourselves under this bill to the decision-making processes and the cosh of the European Council, not only is it completely humiliated this country, but it has actually put us into an impossible situation under the withdrawal agreement, because the fact is, Article 4 of that agreement, which is directly relevant to everything we're discussing here, because it's about the governance of the European Union in relation to the United Kingdom on leaving, actually stipulates in UK terms that we will be subjugated to the decision-making of the Council of Ministers, and I hope somebody on the front bench on the other side of the House will just take this on board. The Council of Ministers will be making laws for probably up to 4 years, when this House, as I said the other day, will be politically castrated in relation to the European treaties, which will have entire competence over us and all laws, and we will not be able to pass a single law in contravention of that, and our courts will not be able to defend our voters, our taxpayers, from any of the decisions that are taken while we are put at the mercy of our competitors during the transitional period, however long that may be. Now, I've already made the point that it could be the transitional period may cost £90 billion. I don't know, because we don't know what date will be settled on yet. What I do know is that the subjugation of this House, the complete neutrality, the neutralising of this House in the transitional period, and I see that the Minister is shaking his head. Well, I invite him to appear in front of my select committee and answer the shaking of that head, because I'd like to cross-examine him on the question of who will be governing this country during that period, because it's certainly not going to be this Parliament. I can tell him that. I'll go ahead.
Does my rightful friend share my concern, which is why I have put down the amendment that I have, that this House seems to happily think it can put a date on this bill and that the Prime Minister will go off and secure the date? It seems to have lost sight of the fact that we will probably have to take what we are offered, or maybe not offered anything at all. The point of this bill seems to be, to me, that we assume that the European Parliament will take notice of what we wish to happen.
Absolutely. The idea of our subjecting ourselves to the European Council as well as to the European Parliament is about as humiliating as anybody can imagine. I mean, we actually, I suppose we're not supposed to say this, but it happens to be true, we saved Europe twice in the last 100 years. And yet we're now, as a result of this withdrawal agreement and these provisions, actually subjugating ourselves to the decisions that are taken by 27 other member states by majority vote. And I see that the front bench spokesman is chuntering. Perhaps he'd like to come to the dispatch box and make his point. No, he's not going to, because he can't understand what I'm talking about, because he hasn't actually got the competence to do so. That's the problem. Because if he doesn't understand what I'm saying and really tell his constituents that the control over laws issue and the qualified majority voting of the lawmaking of this country for a significant number of years is going to be conducted without our being able to do anything about it at all. There is no veto power in this arrangement. We're just entirely subject to it. It may be a reason why the front bench of the official opposition are voting against this, amongst other things. Maybe they realise how dangerous it is, because it's certainly very dangerous for a lot of workers and trade unionists, as we found out in the ports regulation, in that every single port, every single trade union in every port objected to it, and yet it went through. And this is going to be the continuous activity of the Council of Ministers into the indefinite future, or certainly during the next few years. Now, with regard to the question of what the Prime Minister is to do, what will the Prime Minister do? on the basis of the fact that Section 1.6 seems to assume that the resolution would already have been passed or at least proposed. As that cannot happen before the 12th of April, then there would be a motion, after which we have to ask the question, what is the Prime Minister going to do, and what indeed is the European Council going to insist on? But that is not what the bill proposes that she must do. And frankly, I can't see how she could do so without getting parliamentary approval for it. The bill merely talks about the Prime Minister having to seek an extension, not having to agree to one that is gratuitously offered by the European Council. I mean, this is complete madness. In short, the bill is a complete and total rubbish dump. And I think if it is enacted tomorrow, I would be fascinated to know what the government is going to be able to do about it, because this will become the law of the land. And I cannot imagine, I think it was Alice in Alice in Wonderland, said, I can't believe, she was asked about things being possible or impossible, and she said, I believe 6 impossible things before breakfast every day. This is a perfect example of just that. Then there is the further issue of UK law and exit day. At the moment, exit day is redefined in the statutory instrument that went through, I believe, unlawfully, but we'll park that one for the moment, will be the 12th of April, unless the House of Commons approves the withdrawal agreement. This bill assumes that this will not be the case. So exit day has to be the 12th of April under UK law. The bill says nothing about changing that. And as I read sections 2 and 3, and 23 and 4, a minister cannot propose a change to exit day by laying a statutory instrument until the proposed extension date has been agreed with the EU. Exactly. So unless all this is tied up on the 11th of April, which seems impossible, as I've just said, how is UK law to be changed? By UK law, in those circumstances, of course. I'd love to give way to the person who generated this rubbish.
And thought it would be particularly productive to intervene in my honourable friend's remarks, with, I think, literally all of which I disagree profoundly. But I just thought on this one point it would be productive, because there is a fact about this, which if he looks at the list of amendments, he'll see the government has moved new clause 13, which many of us feel is a very sensible new clause, and which we propose, therefore, to recommend as acceptance, as something we should accept, which specifically provides for a negative resolution SI to be substituted for an affirmative resolution SI, in order that it could be made immediately upon being deposited, rather than awaiting the approval of the House. That obviously could later be subject to revision under the negative resolution prayer procedure. But of course, we'd all have to be a gang of lunatics not to keep the exit day in line with international law if, as a matter of fact, for better or worse, the Prime Minister had agreed a given date of exit. So I think, alas, the honourable gentleman is, my honourable friend holds the full, but I just point this out to my honourable friend because there has actually been a discussion about all this, and there is a perfectly sensible way of solving the one point he has raised, which is a serious point, which is solved by government's new clause 13.
I've made one serious point, because actually I think that my right honourable friend is in serious trouble. And I say that because every time he gets up and starts interpreting the bill, which is his bill, that is going to be taken into account, quite likely, if there is any judicial review on any of the provisions of this bill as enacted. And therefore, every time he opines on the question of interpretation, as all ministers ought to know, and as he is now the minister in charge of this day and various other things that he seems to have assumed to himself, the fact of the matter is that those interpretations he's placing on it in a rather fulsome manner could turn out to be used as a means of interpreting what is meant under the bill. So I think he ought to be a little bit more cautious, but I've waited until this point because he's said quite enough to put himself into quite a serious difficulty on that account. But having said that, With regard to new clause 4, what I'm saying is that any motion brought forward under section 1.1 in the form set out in section 1.2 may be amended in line with section 1.3 only to include a date. In a nutshell, this new clause would prevent further amendments to standing orders and so on. I now move on to new clause 5, and that one says, because I want to get these on the record.
Moves on to new clause 5. I know that he has a lot to say about these amendments which the House must hear, but I'm hoping that he might possibly do so in an expedited fashion, because we don't have a lot of time left, and I'm sure the honourable gentleman also wants to hear what the Minister and others have to say. Sir, a point of order, sir?
Mr. Speaker, I'm very grateful. You mentioned time. This is a question that was raised earlier about the timing for third reading. Are you able to advise the Chamber at this stage at what point third reading will happen, and if there are any amendments and the subsequent debate on that at that stage?
No, it's not up to the Chair, it's up to the House when third reading is likely to occur, and my estimate of the way things are going at present is that third reading will not occur, because the committee stage is likely to take the whole of the time available. But that's entirely up to the House. If the people who still wish to speak for a short time, we will have a third reading. If they speak for a long time, we won't have a third reading. Sir William Cash.
Most grateful with respect to you, Madam Deputy Speaker. This bill has been truncated. It has also, and I say this to you because you know what I'm talking about, it has been rushed through. This bill is not only an abomination in its own right, but it is also it's gravely unconstitutional. It offends so many of the conventions. It offends Standing Order 14 and so on and so forth. So I am not going to just simply fail to make the points that need to be made on this bill. I'm so sorry, but I am going to do it because they really have to be made. And it's now only 8 minutes past 9, and we have until 10 o'clock. So I am not going to, if I may say with respect, although I greatly respect you, Madam Deputy Speaker, I am going to make my points because they really need to be made. And furthermore, they are matters which are germane to trying to sort out the rubbish that this bill is generating for the British public. That is the point I wish to make. So, as I was saying, with respect to new clause 4, new clause 5, I mean, that states it's about the amendability of motions. Any motion, I say, brought forward under section 1.1 in the form set out in section 1.2 may be amended in line with section 1.3 only, and I say only, to include a date no later than the 22nd of May 2019. This new clause would prevent further amendments to standing orders or to the business of the House of Commons, and would impose a maximum duration of the extension period. Now, given what I've said about the fact that this bill otherwise would cost, according to my exchanges with the Minister, the former Minister, member for Falmouth, I think it is, £90 billion, I think we'll all be doing the House a very great service, much more than the House, which is pretty chaotic these days, but a great deal of help to the taxpayers and our constituents by placing a restriction on the length of the extension period, because if it were to go on according to the potentiality of these clauses in this bill and went to extend to 5 years, it would cost £90 billion. And I'm just making a statement of fact, and that is a very good reason for voting against this bill. So this amendment would, as I've said, place a maximum duration on the extension period, and that is an enormous step in the right direction. In fact, it's a fundamentally vital provision in the context of this bill. Now, I now move on to the other new clause, which is in my name, which is new clause 5. That was new clause 4. I move on to new clause 7. New Clause 7 deals with the question of European elections, another hot potato. What the amendment says, it's a new clause actually, is no extension of the period of under Article 50(3) of the Treaty on European Union may be agreed by the Prime Minister if, as a result, the United Kingdom would be required to prepare for or to hold elections to the European Parliament. Now, I would have thought there are many people in this House who would be delighted to have this new clause inserted into the bill. I repeat, no extension of the period may be agreed by the Prime Minister if, as a result, the United Kingdom would be required to prepare for or to hold elections to the European Parliament. I'm doing the government's job for them. I'm actually imposing a restriction. And I see the Minister slightly nodding his head, because I think it means that he might actually quite like this amendment, because the bottom line is that I've heard the Prime Minister in her remarks yesterday referring to the fact that we wouldn't want to have European elections. Of course I will.
I'm very grateful that my old friend rightly recollected the Prime Minister herself has made this very point. And would it not be a catastrophic failure of our politics if 3 years after the vote to leave, we are holding elections to the very institution that we voted to leave 3 years earlier? And isn't that why this amendment must be put and, in my view, must be passed as well?
Absolutely.
Absolutely. It's axiomatic. It goes to the very heart of what we're leaving and how we're leaving and what we're leaving. The idea that we would hold European elections, which otherwise, but for my proposed amendment, would be liable to take place, makes me think that somebody in this House really ought to vote for this new clause. I really do. I therefore urge the House to consider that as a very important, sensible introduction. I see that the honourable member for West Dorset has left the chamber. Perhaps my remarks were too unpalatable for him. But the reality is that...
Well, my honourable friend,
yes, of course.
I wonder if my honourable friend, he ably said about the cost of a potential long extension, £90 billion or whatever that might be. Has he considered the cost of running European parliamentary elections to the public purse for a period which may be a very short time in office for those so elected?
Well, I've been told, I've heard it mentioned it would cost £100 million, which is quite a lot of money for nothing. And in some constituencies, as it happens, there has been a turnout of about 19%. I mean, really, Madam Deputy Speaker, the European elections are a complete farce anyway. In fact, I think the European Parliament is a complete farce. Frankly, I think that the opportunity to get rid of them altogether would be a massive step in the right direction. And this is the bill, and this is the opportunity, by the look of it, to do it.
Giving way. But can he also see how the public themselves would have no real engagement in the process if we're actually saying to the public that these people won't be around for 5 minutes because we're all trying to get rid of them? I can't imagine it's good for democracy.
Well, that's absolutely right. And I could enlarge on the reasons why we wouldn't want to have any parliamentary elections, but also why we wouldn't want any MEPs, because they cost a fortune as well. And what is more, a lot of them are, by all accounts, engaged in activities which are either useless or very expensive. I don't think I'll dilate on that, but it's a matter of fact. And the European Parliament, Madam Deputy Speaker, is a body which has got to make decisions about whether or not we leave. Now, I hear Mr. Guy Verhofstadt opining and pontificating quite a lot. I don't know quite what they're going to do about it all when it comes to the decision that's been conferred upon them. Again, another thing which I find very offensive. If we want to leave, Madam Deputy Speaker, I think we should be allowed to leave without having the sanction of the European Parliament, for example, or for that matter, the sanction of really the European Council. If one thinks about it, the Article 50 prescribes an arrangement under which you leave the European Union under the law. It so happens that it's under the European law, but it's also under our own domestic law, because the Lisbon Treaty Act, as I call it, is itself a domestic enactment which binds us. So for practical purposes, the European elections will be taking place in a context which is within the framework of our leaving the European Union under our own domestic law. Why on earth we should imagine that we're going to be caught up in them, or even remotely accept the idea that we would be, completely escapes me. When we entered into the Article 50 revocation, what we did was, as a matter of, as a country, as an equal party to the other 27. Yes, there are 27 of them, but in law, because we are the country that is leaving, we are on an exactly equal footing as they are, which is why we should never have allowed ourselves to be trapped into the arrangements of the guidelines and the terms of reference and the sequencing laid down by the European Union. So, as far as I'm concerned, it's very simple, Madam Deputy Speaker. We cannot possibly be past the European elections. Now, turning to the last one, that is the question of Northern Ireland, Wales and Scotland. And this amendment, which is clause 2, page 2, line 7, I'm saying that we need to insert, having left out the words from, quote, force, close quote, for those who are able to follow the wording, we should insert, and I think this would appeal to the Scots Nats, possibly quite a lot. It says, subject to the, and also to the members of the Northern Ireland Assembly and the Assembly of Wales. I've put in, subject to the approval of the Northern Ireland Assembly, the Scottish Parliament and the National Assembly of Wales, on such day as the Minister, as the Minister of Crown by regulations appoints. Of course I'll give way.
Could you just tell me when he next expects the Northern Ireland Assembly to meet?
That's a very good question, because it may well be after exit day on my proposals. And that's the point. I'm making amendments which are intended to provide that democratic element which is needed amongst the people of Northern Ireland, Scotland and Wales. I did wait to remember.
Very grateful to the right honourable gentleman for being so clear about what's in Scotland's best interest. Could he remind us, did he support the need for a legislative consent motion or for the consent of the Scottish Parliament before the European Union Referendum Bill was passed, which he supported, before the Article 50 Revocation Act was passed, which he supported, before last year's Great Repeal Bill was passed, which he supported? It seems to me that he supported an awful lot of EU-related legislation that's been extremely damaging to Scotland, not caring a jot as to what the Scottish Parliament or other devolved institutions thought about it. Why is it he suddenly now wants to invoke the right of the Scottish Parliament to be consulted when he and his party have trampled over that right ever since the Brexit referendum was thought of?
Be that I actually want to make some trouble. And it may be that I think the people of Wales and of Scotland and of Northern Ireland have got a very strong interest in the extent to which they are involved in this process. And this is a means to provide them with an opportunity to do so. So nothing I'm not going to contradict what you just said. What I'm saying is that I do believe that if under our constitutional settlement there are assemblies for Northern Ireland, the Scottish Parliament and the National Assembly of Wales, I would have thought that they would be extremely interested to know whether or not they were being cut out of the process that's been prescribed here. It's not my fault that the government's come forward with proposals and they've had all these joint committees which the various leaders of the different devolved assemblies have been complaining they haven't been properly involved in. I'm giving them a chance to be involved. So the honourable member may be right about the legislative consent point, but I think I'm right in thinking that in relation to this crazy bill, it would be at least useful for the people of Northern Ireland and Scottish Parliament and the National Assembly of Wales to be able to make their contribution in their devolved legislatures, and therefore I think it's a point worth making, and I'm intending to move that particular clause to page 2, line 7, when I come to the time of voting, because that's the one which of all the ones that I would want to move most, it would be that one. Thank you.
Sir Bernard Jenkins.
I'm very happy to give.
Sir Bernard Jenkins.
I'm most grateful to the Honourable Lady, and Right Honourable Lady, I'll be as brief as I can. I want to speak against Clause 1 stand part, which is the heart of this bill, the strategic intent of this bill, which is about trying to put this House in a position to stop the United Kingdom leaving the EU on the date that the government might want us to leave. There is no question about that. And I very much agree with my honourable friend for Falmouth and Camborne, who made the point that, of course, the process of attrition in this House to try and limit the government's negotiating freedom has, in the end, undermined the government's ability to get a better deal, to negotiate from a position of strength, because if you can't walk away from the negotiation you're in and you have to agree something at the end of it, well then the other party simply calls the shots, and that certainly strengthened the hand of those who want us to have a very bad deal. But and I've already made some points in one of the earlier business motions about the constitutional impropriety of this whole process. And I think I just do invite the committee just to reflect on what this House looks like tonight as we are discussing these highly technical issues. I think what the British people expect us to be discussing are the big principles of whether we should leave without a deal, of whether we should leave on WTO terms, or whether we should sign up to the withdrawal agreement. But this particular debate seems to me particularly obscure and unavailable to the voters, and will make this House look particularly out of touch, and particularly because this bill is somewhat otiose. I have been arguing for some time amongst my colleagues on these benches that the Prime Minister has demonstrated very little intention of ever leaving without a withdrawal agreement, and the fact that the government has spewed out a whole raft of information about basically why it does not want to leave without a deal, I think underlines that point. So I think this bill is unnecessary. I also, in my comment to my honourable friend, the chairman of the Select Committee for European Legislation, European Scrutiny, I pointed out that actually it's unenforceable, and in fact, if you just look at the wording of clause 1(4), the Prime Minister must seek an extension of the period specified in Article 53 of the Treaty on European Union. Well, how is that? What does seek mean under these circumstances? What happens if the Prime Minister makes a telephone call asking for an extension and says thank you very much and puts the phone down again? How is this going to be scrutinised? How is this going to be made accountable? How do we judge a serious seeking, an in good faith seeking, from a mere technical seeking? This underlines the total futility of this House attempting to legislate in this way, because our system of government is not set up for Parliament to legislate detailed instructions on how ministers should carry out their duties. We tend to make laws on a much more general basis, not on that basis. And that's why the system just does not work. I give way to my other friend.
Because he's making a really important point, and it builds on other points that have been made during the course of this committee stage. But is there not a further defect as well, which has been pointed out? There's no time frame. The Prime Minister isn't mandated to seek in any manner within any particular time frame. Therefore, she could, following this bill, legally complying with this bill, in fact do nothing until the 13th of April and still be intending to fully comply with the bill.
And we absolutely know why this bill is framed in these terms, these very vague terms. It was precisely in order to avoid falling foul of the rules that would require a money resolution for a bill that gave a more specific instruction. I give way to my honourable friend.
My honourable friend and my good friend is making some very, very good points. It also raises the question of scrutiny, which he just mentioned. Not only with my own committee, undoubtedly is trying to work out how to deal with this scrambled eggs, but actually also, how is the House of Lords going to deal with this when it gets to them? Because they've suspended or disallowed Standing Order 72 in their own House. So are they in fact going to truncate their business to such an extent that they won't be able to get this right? Who is going to get this right?
I'm not going to attempt to answer that question because it answers itself. That nobody is going to be held accountable for what goes wrong as a result of this bill. But I just also point something else out, that if the Prime Minister does go to the Council, as I expect, as I've long been reconciled to expect, what really matters is the conditions to the extension that comes with the extension. Well, where is the accountability for the conditions she's going to apply? Or is she going to simply go to the Council, accept an enforceable agreement with conditions, and bring it back fait accompli to this House, as she did with the original process? I'm going to press on, if she would allow me. And I've already addressed the legitimacy point, the enforcement point. But let me just go back to this whole question of legitimacy, because it's not just legitimacy, the illegitimacy of this whole process and the concept of the House legislating to instruct ministers outside the control of ministers. But as I said, there's been a huge government campaign, some might call it a fear campaign, supported by the second referendum campaign, supported by other very well-funded lobby groups and business interests, and the arguments in favour of leaving without agreement have pretty well been disposed of by default. They don't get a hearing. And one can think of one or two broadcast outlets that just delight in ridiculing perfectly respectable arguments. I have a document here called 30 Truths About Leaving the EU on WTO Terms. And it goes through all the canards that have been talked about. For example, how leaving without an agreement would leave us with an extra £39 billion to spend on our own priorities, which over a couple of years would increase the GDP of this country by about 2%. How it would end uncertainty much more quickly, how the administrative, every party involved with the Irish border has said there is going to be no infrastructure at the border in the event of a no-deal Brexit. And so it goes on. I shan't detain the House now, because now is not the time to make these arguments. I just make the point that these arguments have simply not been made. And yet, despite that, a very recent poll conducted by YouGov shows that, that where an extension is an option, 40% would support a no deal, only 11% would support an extension, though 36% would still support Remain. But the point is, the most popular option out there in the polls at the moment is leaving without a deal. So who does this clause represent? That's despite the deluge of propaganda that's been emptied over. There's been, no, the honourable gentleman laughs, but there has been no Leave campaign conducting any effective campaign out there in favour of no deal. And despite that, and the government itself, which pretended to say they were in favour of no deal is better than a bad deal, they haven't conducted a campaign to reassure voters that leaving without a deal is a sensible option. Despite that, the British people want to leave. And nobody, who in this House was elected to put this bill through Parliament? Who in this House was elected to say, when I am elected, I am going to put a bill through this House to delay Article 50? Not the Honourable Lady promoting this bill. She was elected on a manifesto to leave, and she is now defying that manifesto and defying her voters and her own constituency who voted leave. And you know, if you remove the extension option, the no-deal option goes up to 44% against 42% to remain. There's been no campaign, there's been no Leave campaign being conducted in this country for the last 2 or 3 years, and yet that's what the British people think. Just imagine if we had a government in this country that was really enthusiastic about leaving the European Union and had conducted its policy positively, explaining the benefits of leaving the European Union, if necessary on WTO terms. It would be by far the most popular option in the polls today. And I believe that even at this late stage, if the government actually took us out of the European Union on WTO terms, our party would enjoy a huge leap in the credibility with the British people. Oh, not in this House, because this House is full of people who voted Remain, who want to stop Brexit, despite the vote of the British people in the referendum.
Peter Grant.
Thank you very much, Madam Deputy Speaker. Well, how do we sum that up in 10 minutes or so? A pile of mince would do it in a handful of words. Can I first of all address some of the absolute nonsense that we've had from the no-dealers across the chamber? Can I first, though, welcome the fact that they're finally coming out for who they really are? Because these are the people who campaigned for the various Leave campaigns, promising us that we would leave with a good deal, it would still remain part of the customs union, the single market. That's what the Leave campaign are saying. And as for this story that there's been no Leave campaigning done, has he not seen the revelations again in the media in the last couple of days about intensive, targeted social media campaigning funded by who knows where? I don't know. We don't know. I wonder how many people on the other side of the chamber maybe know where this money is coming from. And as for the complaint that we haven't had enough time to debate the big issues of Brexit, these are the people that didn't want Parliament to have any say at all. They went to court to stop Parliament from being allowed to see the Prime Minister's deal before it was too late to change it. And now they come along and complain that there's not been enough time to scrutinise it. These are the people who allowed 19 minutes of debate before the biggest power grab from Scotland ever seen since the introduction of the Scottish Office. 19 minutes of listening to one Conservative minister droning on, and then the thing was pushed through. And how many of them complained then about the lack of time?
None.
Mr Deputy Speaker, as far as the amendments are concerned, I'm disappointed, although I obviously accept the decision, that the amendments that would have given some kind of firm reason for wanting to extend Article 50 have not been taken. That will be something that the House will need to come back to in due course, and I hope that at some point the House will agree not only that Article 50 needs to be extended, but that whatever deal the United Kingdom intends to leave on is put to the people, so that the people will confirm this is what they thought by Brexit, because I can tell you what most of them didn't think that was meant by Brexit. They didn't think it was no deal, because even the Leave campaign never said they were campaigning for no deal. I won't go through all the individual amendments, but anything that seeks to say that the extension can only be for a matter of days or weeks, we will oppose. Because it is nonsensical to think that the bad deal that we have just now from the Prime Minister is going to get significantly better in a matter of weeks. If there's going to be an improvement to the deal, it can only come if we get a longer extension, so that we can reset the whole process. The Prime Minister can do what she should have done almost 3 years ago. As soon as she became the leader of a minority government, she can act like the leader of a minority government and talk to politicians and parties across the House to look for areas of agreement and consensus before she starts to draw red lines that paint herself into a corner. And let's remember that the EU has never said that the present agreement is the only one that's possible. They have said it's the only one that's possible, given the Prime Minister's red lines. As far as the one that the Right Honourable Gentleman from Stone was so enthusiastic about, I found it interesting that he spoke for over half an hour when he was speaking, and it felt like it was as long again when he was intervening or raising points of order. And he forgot to mention what the real purpose of his amendment number 6 was all about, or was it new clause 6, I can't tell. It's not about giving Scotland and Wales and Northern Ireland a chance, because if he was that bothered about giving the devolved nations a chance, he would have removed a similar amendment for all the legislation that's leading to us being dragged out of Europe in the first place. No, the crux of that amendment is right at the end, where it says that after consent has been gained from the devolved assemblies, including the one that doesn't exist at the moment, The Act comes into force on the day a Minister of the Crown decides it comes into force. So even if Parliament overturns the wish of the Government, imposes its will on the Government can ignore the Act completely simply by not bothering to bring it into force at all. So for that reason, that clause, it's got a wee bit of sugar coating on it to try and sort of fool the Scots, the Welsh and the Northern Irish. We're not going to be conned by that. We're not going to be supporting it. I've also got a big problem with new clause 13, because that allows the Government effectively unilaterally to change the date. So I'm hoping the Minister can give some kind of assurance as to in what circumstances that power would be used. And in particular, because we know there have been instruments previously that have been prayed against by hundreds of honourable and right-honourable members in this place, and their objections have been ignored. The instruments have just been implemented anyway. So can we get an assurance that if these instruments are prayed against by any of the major opposition parties or by a given number of individual members of Parliament, that the Minister, on his honour and in the Government's honour, will give a guarantee that will not be progressed with? Because we need something as firm as that. Because it's one thing to get promises from the Prime Minister just now. We don't know who's going to be the Prime Minister when these provisions are going to be considered. One of the amendments is specifically to make sure that we can't take part on what is described as a waste of time of an election. Who on earth is scared to take part in an election? Who would want the entire nature of our future relationship with the European Union to be defined purely by the fact that we had to get out before horror of horrors that gave our people a chance to participate in part of the democratic processes of the European Union, democratic processes that the Brexiteers have been telling us for 10 years don't exist because they've denied that it was a democratic institution we were part of anyway.
Very grateful to my own friend for giving way, and of course isn't that the whole thing that Brexiteers say, that the 2016 referendum was about giving people control back? And yet we see the party, and maybe other parties in this House, running scared of the electorate now. Isn't that just going against the wish of people in 2016?
Absolutely. And as for the idea that we shouldn't take part in them because we don't know how long the members of the European Parliament will be there, some of them are never there anyway. I remember the Scottish Regional Council elections in 1994, which we knew were for a very limited time. They actually had a higher turnout than elections had been previously because people were energised and motivated and understood what they were about. If the hardline Conservatives don't want to take part in the European elections, that's entirely up to them. But I don't want my constituents being denied the opportunity to vote for a representative in Europe, whether it's for 2 days or for 2 years or for a full parliamentary term. So, Mr Deputy Speaker, will certainly support the redrafting amendments that have been submitted by the movers, or the sponsors of the bill. It's a bit much, given how many Lord's amendments are often required to sort mistakes in government legislation produced with all the resources the government has at its disposal, to get nitpicking about the fact that there have been a couple of drafting errors in the putting together of this bill. It would have been nice if we hadn't had to rush it through in such a hurry. It would have been nice if the government actually listened to what Parliament has been saying on backbench committee debates and in opposition day debates for the last 3 years. It's because the government have refused to listen. The only way to make them listen is by Act of Parliament, and that's why we'll support the 2 amendments that have come through just now, and I hope to see this bill go through to a third reading.
Shadow Minister.
Thank you very much, Mr Deputy Speaker, and I'll not repeat the general points that I made at second reading, but do want to just briefly, you'll be pleased to know, outline the opposition's views on the various amendments. Now, we will obviously support Amendments 13 and 14, which are helpful drafting amendments, and we will equally obviously vote that Clause 1 and Clause 2 stand part of the bill. We will, and I look to the Minister on this point, support Government new Clause 13 on with a clarification from the Minister. Normally we would want to support the affirmative procedure, but we do accept the Government's reasoning in this case, given the fast-moving situation and the need to ensure consistency between EU and UK law. So, subject to an assurance from the Minister now at the dispatch box that if one of the principal opposition parties prays against the SI, the Government will urgently facilitate a debate on the floor of the House. We will, Mr Deputy Speaker, oppose all the other amendments, and let me explain briefly why. Amendments 20, Amendment 1 and new clause 5 seek to impose different dates, and we really should have learnt from the Withdrawal Act that putting exit dates in statute at this point denies the flexibility we might need, and it's clearly designed, these amendments are clearly designed to frustrate the objectives of the bill. We'd oppose Amendment 21 because we believe it's right for the government to come back to the House if the EU offers a different date. We oppose Government Amendment 22 because it undermines the purpose of the bill in relation to parliamentary approval to seek or agree an extension. We oppose Amendment 6 because it's designed to frustrate the process, and as has been pointed out by honourable friends, of course the Northern Ireland Assembly isn't actually sitting. We'd oppose new clause 4 because it limits Parliament's opportunity to shape decisions, and we'd oppose new clause 7, and I'm surprised that after his lengthy contribution the Honourable Member for Stone isn't here to hear our views on all of these different points, but we'd oppose his new clause 7 because it's seeking to put on the bill a date without saying so. And it puts the cart before the horse. We shouldn't be seeking to determine what extension we need, and we should determine what extension we need and then deal with the consequences. Even if that means, not ideal, but even if it means elections, and not limit ourselves in this way. And if we do, Mr Deputy Speaker, if we do need a longer extension, we would presumably want the UK to have a voice in institutions, not simply the Parliament, but the Council, the Commission, and presumably a UK judge in the Court of Justice. So on that basis, we would oppose that and the other amendments I've identified.
Thank you very much, Mr Hoyle, and I shall be brief as this briefest of committee stages demands. The government continues to oppose this bill, but given that it has passed to committee stage, I beg to move the government amendments. First of all, Government Amendment 22. As the Secretary of State set out earlier, the government has no choice but to improve this bill and limit its most damaging effects. This amendment addresses the dangerous and perhaps unintended constitutional precedent that could be set by this bill, which calls into question the government's ability to seek and agree an extension with the European Union using the royal prerogative. It is a well-established constitutional principle that heads of government are able to enter into international agreements without preconditions set by the House, which constrain their ability to negotiate in the national interest. Government's authority in this matter must not be undermined, as my right honourable friend, the Secretary of State, made clear earlier, and as the honourable gentleman for Camborne and Redruth set out in his speech. Exit day in international and domestic law is the 12th of April. There is a real risk created by this bill that we could be timed out and unable to agree an extension with our European partners and implement that extension in domestic law. This bill, as currently drafted, actually increases the likelihood of an accidental no deal, an outcome which this House has repeatedly voted against. The new process created in this bill could mean that we are timed out and no extension could be agreed. For example, on the 10th of April, the EU could propose an extension of an alternative length, and under this bill, the Prime Minister must then return to this House to put forward that proposal. But by 11th of April, by the time this House had had time to consider that, the Council would be over. We would need to confirm UK agreement to the EU proposal and get an EU Council decision before 11 p.m. on the 12th of April, and I struggle to see how we could carry out such a negotiation through correspondence in 24 hours before we leave. It therefore increases the likelihood of an accidental no deal. We seek to avoid this through this amendment, which ensures the government can agree an extension, regardless of the process set out in this bill, in the national interest. The amendment protects the government's ability to reach agreement with the EU on the extension of Article 50, and I must remind the House that any extension must be agreed jointly between the UK and the EU. I am concerned that the restrictions, therefore, that this drafting in the bill would seek to impose, and I understand that earlier drafts of this bill contained a clause very similar to the one that the government is putting forward in this amendment, and I wonder if the honourable lady in her summing up, right honourable lady, could perhaps address for what reasons it was taken out. out. The amendment from the government simply, therefore, seeks to clarify the position on the royal prerogative, ensuring that nothing in this bill could actually prevent the government from being able to seek and agree an extension of Article 50, which I believe is what supporters of this bill actually want. It is also a hopeful outcome of the process of talks that have been taking place between the government and the opposition, so we can agree the shortest possible extension to leave with a deal. And for these reasons, I urge honourable members across this House to support the amendment. If I can move to Government New Clause 13, again I'd repeat this: we're not moving these amendments because we support this bill, but because we feel it is important to improve it and to limit its most damaging effects, given we are here in committee stage. The new process created in this bill could again mean that we could be timed out and no extension could be agreed. And as the honourable gentleman opposite, I think, accepted, the logic of this amendment is to remove risks of an accidental no-deal situation from that. Right now, happy to give way to the honourable gentleman.
How he intends to use this power under New Clause 13, because by my reading of it, they could negotiate a very long extension, put that through using the negative procedure, and then cut that very short indeed using the negative procedure. So what reassurances can he give us that this is not going to become a power that either this government or some future government could abuse to undermine the will of the House and force us into a no-deal Brexit?
I think the honourable gentleman misunderstands the nature of the power, which is to simply reflect in the UK the agreement which would have been reached by this stage with the EU on any extension. It's not about setting a completely different date. It is about reflecting that agreement. And perhaps I can come to the assurance that have been sought by, I think, both the SNP but certainly the opposition front bench on this, that of course, if a negative SI is prayed against, we would facilitate an urgent debate in that context. But I have to bear in mind, in that respect, that the reason for this change and the reason why we are seeking to move from the affirmative negative is simply to provide the speed which I think this House would want to see in the context that a deal had been agreed. And I don't intend to detain the House much longer on this issue, but it is worth bearing in mind that the current arrangements require an SI to be debated and approved in both Houses under the draft affirmative procedure, and the time for which could put this critical process of approval at risk. This amendment therefore seeks to amend the parliamentary scrutiny procedures applying to the power in the EU Withdrawal Act that can be used to amend the definition of exit day. The scrutiny would be changed from the draft affirmative to the draft negative procedure. It is only prudent that we are able to make the SI under the negative procedure to ensure that our statute books reflect what is agreed in international law, avoiding a crash-out exit. And for these reasons, I urge honourable members and right honourable members across the House to support this amendment, and I'm happy to move this amendment. But I continue to urge the House to reject this bill, which is not needed to avoid no deal, because the government has already undertaken to seek an extension to ensure we avoid no deal. Like many colleagues who have spoken today, I want that extension to be a technical one to ensure that we leave with a deal. And with that, I'd be keen to hear from the right honourable lady.
Thank you, Mr. Deputy Speaker. I wanted to just try and briefly respond to what I think has been actually a very thoughtful debate about some of the detailed amendments that have been put forward. Just briefly responding where the Minister left off on New Clause 13, I'm very happy to follow the Labour front bench recommendation to accept New Clause 13, given the very tight timetable I know the Minister will be operating into. It's not a core part of the bill. The amendments 20, Amendment 1, New Clause 5 and New Clause 4, I believe we should oppose those amendments. They are all in different ways attempting to restrict the flexibility of the Prime Minister to put forward a proposal to this House. And in fact, at that point, once the Prime Minister has put her proposal to the House, it will be up to the House to reject the proposal or amend the proposal at that time. So all of the points that honourable members have made in wanting to restrict the primary legislation, actually they'll be able to argue those points in the point at which the motion is put forward. That's the proper time to debate those. On New Clause 7, I do understand the concerns about the European elections, because I don't personally think it makes much sense for member states that are part of the Article 50 process, that departing member states should be covered in the same way. But I would just draw members' attention to the legal opinion drawn up by Lord David Anderson QC and 5 other top lawyers, which says the right to participate in European Parliament elections may be derogated from under EU law. They lists a series of points. Now, I understand there will be political debates about that, and I also think that all honourable members will figure the most important thing is for us to get this right rather than be constrained by this issue, and therefore I don't think this is an appropriate amendment to accept. Nevertheless, I do think that members should take seriously, and the government should take seriously, the legal opinion that has been put, which does list a series of ways in which they think it would be possible to not the short of treaty change that would be possible to avert the UK having to participate in European elections. I want to then particularly move on to Amendment 21 from the member from Camborne, and also Government Amendment 22, which I think is an important one. The Minister asked me why that a similar provision had been included in previous bills. The reason for that was because in previous attempts we were thinking we would be legislating at a much earlier stage, and therefore there might be a period of some weeks in which the Prime Minister shouldn't be restricted from seeking an extension of Article 50 in advance if that was thought to be necessary in order to prepare, and we didn't want to restrict the Prime Minister's hands in this way. The concern that we would have about the way it's framed now is that it appears to end up undermining the purpose of the bill. I'm not sure if that's his intention to do so, and therefore I think maybe that we should have further discussions if his amendment is not passed, which I would resist his amendment tonight because I don't want to undermine the purpose of the bill. But I do think it's obviously important to ensure there is complete clarity over, of course, the government's flexibility, the Prime Minister's flexibility in the European Council to be able to take decisions in the European Council. Of course, she has that flexibility. I give way.
I'm grateful for the Right Honourable Lady for that clarification. I think the government would still press that amendment. We feel it is right to do so to protect the powers under the royal prerogative. I can assure her it is about providing that flexibility, and of course the process that her front bench and our front bench are engaged with may require that flexibility, whatever the House chooses to do on this legislation. We continue to obviously oppose this bill, and I should just mention, as I didn't mention in my speech, that we would also encourage colleagues to support Amendment 21. Thank you.
I would, I think, say in response to him, because I would argue for opposing both Government 22 and Amendment 21 at this stage, but that if they do not pass and the bill passes to the other place, then I would be very keen to have further discussions with him about how we can make sure that there is appropriate clarity for something that I think we all want to see, and to make sure that the government can do this in a very orderly way. And then on that basis, Mr Deputy Speaker, I hope that we can support the drafting amendments that I have referred to. I will personally support new clause 13, but I would urge the House to resist the other amendments, and I hope there can be further constructive discussions to make sure that this bill does what we want it to do, which is simply to support the Prime Minister's work to avert no deal, and to make sure that we don't end up putting our constituents at risk while this important process that the Prime Minister has instigated, we hope, can be successful at getting agreement on a way forward.
Yeah. The question is that Amendment 13 be made. Does many of that opinion say aye? Aye. The contrary, no. I think the ayes have it. The ayes have it. I call George Eustace to move Amendment 21 formally.
I beg to move.
The question is that Amendment 21 be made. Does many of that opinion say aye?
Aye.
The contrary, no.
No.
Division, clear the lobbies.